Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives in New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning. Oh my. I'm a little bit late today. We have some sort of illness going around this house. And there's some interesting developments this morning. For those of you who don't know, the first hearing will not be streamed. I've got an old Zoom link. So I'm in the Zoom room. I don't know if they're not going to turn the Zoom on, then we're not going to get it. But here's what's going on for those of you who don't know. Last night, Aidan Kearney tweeted the following. Let me pull it up for you. The world is watching. Oh, you don't even know. You don't even know. Well, for posterity, today is what is today? Today's date. Today's Thursday, March 20th of 2024. And Karen Reed was still framed. Thank you so much for coming to spend part of your morning with me. Here's what's happening this morning. The final pretrial conference is supposed to happen in front of Judge Kearney with regard to the Karen Reed case today at 9 a.m. However, this is what happened last night at about 9:46 p.m. to be exact. This is what Aidan Kearney tweeted, aka Turtle Boy. Tomorrow is going to be interesting. Karen Reed and I will be sitting together at the defendant's table in the main courtroom at 9 a.m. in front of Judge Doolin. Hank Brennan is interceding, I think he means intervening, in my case for a Rule 17 motion for my phones. And we know about that motion because we went over that motion before, but we can look at it again if we have some time before, if and when they stream this hearing. And we'll take a look at that because we knew that they made this Rule 17 motion for Aidan's phones. We went over it already. Boston 25. And then he says, after that, the hearing will move into the small courtroom for the motions hearing with anti-Bev. So when you say Boston 25, are you saying Boston 25 has it on YouTube or they have it on their channel? I don't know. Denise Richards vibes. All right, I'll allow it. I went to Cancun with attorney Melanie Little hoodie on. This is the Bella and Canvas version of that sweatshirt. It is super soft and it's also gigantic. So guide your sizing accordingly. Thank you to the Goodmans who sent me pictures of them wearing merch this morning. So adorable. You guys are so cute. I can't take it. Yeah, everybody just take a breath. Hank Brennan's up to something. We knew he was. We knew he was a dirty player. He's a dirty player. He's just not. He's unlike any attorney I've ever had to go up against. And, a lot of attorneys that I've spoken to feel the same way. And so, I don't know what's going on, except everything that's going on just feels icky. I don't really know how to describe it other than that. It just feels dirty. It feels icky. And I'm going to see if they start the Zoom camera. They may not. And why? Why no transparency? Why can't we see what's going on in this courtroom? I don't know, it makes me mad, but I don't feel really well today, and I also, don't feel like getting my blood pressure up today, so let's all just dirty deeds come dirt cheap. Excellent. Excellent, excellent song choice for the morning. Well, I don't know, I got the Zoom room up. I have so every it seems like the Zoom link is the same every time a courtroom goes live, and it seems to me that this is the main courtroom. And if somebody can just refresh, Fox 25 has it up on their website or on their YouTube. Can you guys please give me some more information? I'll go to their website. Law and Crime has the Doolin hearing. Are you talking about the Doolin hearing? I know what you're saying. We're talking about a different hearing right now. This is a different hearing. This is not the regularly scheduled program in Canoni's courtroom. This is in Judge Doolin's courtroom. This is something that was unscheduled. I don't even know if it is on the docket for today. All right, I see that Law and Crime has the fan up, but I do not know if they are in Doolin's courtroom or if they are in Canoni's courtroom, because it's going to be two different courtrooms today. So I know that you guys are trying to help me, and I appreciate you so much. Doolin is the one that we like. We love Judge Doolin. He's the one who did Aidan Kearney's hearing on March 6th. So remember? So Law and Crime has the fan up. I don't know if he's flying in for Aidan, but if you could kindly refrain from all caps, because that's for mod use. Hang on. I mean, Law and Crime has a fan up. Doolin is the one who, no, that's not Doolin who came up with Colin. That's Cosgrove. That's the attorney. Cosgrove is the attorney he's the special district attorney in the Aidan Kearney persecution, who has renamed Colin Albert, that's Cosgrove. Yeah, Doolin's in the big courtroom. If that helps, it does help, because I have the Zoom feed up for Judge Doolin's courtroom that I got from last time, because I heard they're not giving it out today. So if anybody could just refrain from information in the chat, that is not okay. I'm trying to explain. Okay, Boston 25 says they're going live with it. Can you please tell me if that is the Boston 25 website or the Boston 25 YouTube is all? Yeah, I know Mark Bedrow's in New York City all day, so he's not going to be there. This is an unexpected twist. It's an unexpected twist. Okay, I'm gonna go off screen for a second while I figure this out. If anybody has the real actual information, please let me know. I know everyone. Okay, listen. Here's the thing. Everybody thinks, all of the streamers that you're looking at think that the conference is starting in front of Judge Canoni today at 9:00. It is not. There is an unscheduled hearing in front of Judge Doolin. If you could look at the tweet that's on the screen, Brennan, and we saw these shenanigans 2 days ago. He said, he started talking about harassment, and he said, we have a hearing today. And that was the day that we went and we streamed Aidan's hearing. This is an unexpected twist. So all of the feeds that you see that are up are for Judge Canoni's courtroom. If anybody actually has the actual feed for what is going to be happening in Judge Doolin's courtroom at 9 a.m., please let me know. I was told the clerk is not giving out the Zoom information, but I'm in a Zoom room for that courtroom because it's the same Zoom every time. So, okay, Tom and Mike have Channel 10 for that hearing, but is it on? Is it is it showing? Is it working? Anyone? Is it working? Thank you. Thank you. Thank you. Thank you. Bev is waiting for Doolin's hearing. Okay, I'm gonna poke around. I'm gonna poke around a little bit on YouTube. I'm gonna go off screen for a second. Don't worry, I'm gonna be right back. Okay, so just chillax for a few seconds while I poke around and see if the actual Zoom feed that I have is going to start. So didn't want to be late for you guys. So hold on 1 second. I'll leave the tweet here for you. Hang on. He using? What feed is he using? Can we figure that out? I can see Aidan sitting in the courtroom. Like Law and Crime has camera up, NBC 10 has it up, but they're not in the right courtroom. And it's a little bit glitchy. Do we know what stream he's got? Court TV has it? All right, hang. Court TV has the NBC boss. I have NBC 10 up, but they're not showing it on YouTube. No, he doesn't have Law and Crime up. Yeah, I can hear you. I can hear you, Boston Mike. He says Law and Crime, but let me try. Thank you, thank you, Boston Mike. I've got the Zoom link, but do I have the wrong Zoom link? I mean, I'm in the Zoom room. Courtroom 1. Are they in courtroom 1? I know, we all help each other out, but I need the Zoom link because they wouldn't give it out this morning. Susie, you there? It's a Zoom. There is no Zoom. I don't know if they have something old or new. All right, I'm gonna go just I mean, this is what he's showing, but I don't.
Okay. Thanks, Kelly.
Hey guys. Oh, they're in. This is not courtroom 1. That's why.
So it's the
Thanks,
Zoom.
Kelly.
I have
It's not courtroom 1. That's why I'm in courtroom 1 Zoom
the
room.
code. If I don't know how to get it to Melanie though, because I don't have her email. I just sent it to Bettero, Melanie. If you can.
Yeah, he's in court all day, Mike.
Yeah,
Hang
I don't
on.
know how to send it to Melanie, but I just sent it to
Hold on.
Bettero. If Bettero can let's stand it up. Are we unmuted? Okay.
Tell Mike I just put my email into his chat. He's the greatest.
We just have no volume. I don't know what's going on.
I'm in the wrong Zoom room, apparently.
That's a bummer.
Okay, well then go over to Melanie's then. I don't know what to tell you. Go over to Boston Tom's, but I'm not sniping.
I can hear glare. How do I hear glare on this feed?
Tell the glare that I sent him the Zoom.
I just put my email in Mike's chat. I can
There
hear
you go. You
Glaire's
got it.
voice.
Boom.
Here comes Brennan.
May. Your Honor, what the Commonwealth
You guys
is
hear?
seeking is phone data on 2 phones that were seized in search pursuant to a search warrant, and those phones are involved in the case of Commonwealth versus Kearney. And before you is Mr. Kearney and his counsel. From the public available pleadings, what I've learned is that there were search warrants for Mr. Kearney's phone. 6 search warrants were seized. 2 of those phones were searched pursuant to the warrant. They did not have any limitations such as a paint team, and they've been, according to the public pleading, thoroughly searched. The other 4 phones, we are not interested in pursuing any information on the 4 phones that have not been searched yet. The information on those phones, as I understand, is not subject to any protective order. It is in the custody and the control of the Norfolk County District Attorney's Office. Frankly, I don't know if a Rule 17 subpoena is necessary in this case. I've searched the case law. I do not see any case law that specifically says under these circumstances, a Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, special prosecutor Cosgrove, is specially appointed to Mr. Kearney's case. Because of that, I have, from the beginning, kept a very strong line of separation between both Mr. Kearney's case and Ms. Reed's case. I have only sought information that's been publicly available. That's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as
Trying
well
to
as my
fix it, just hang
motion
on.
that are on the public docket to Mr. Kearney's case. Because of that, I have, from the beginning, kept a very strong line of separation between both Mr. Kearney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket. And so what I learned is from my public reading and from possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Kearney, but a relationship in where information.
Okay, everyone got their act together, so Law and Crime now has it. So here's what we're going to do. We're going to rewind so we can start from the beginning. Are you okay? I was hearing it 3 times because I had 3 different feeds up. Everyone give Boston Mike, Tom CPU and Boston Mike a big sub and a big thumbs up for letting me swipe their stream for the first couple of minutes. But here's what's going to happen. I'm rewinding it now. We're starting from the top. Hank Brennan is being a slime bag. and he wants Aidan Kearney's phones. So he has to go in front of Judge Doolin to get it. So here's where we start. I'm rewinding Law and Crime. So let's go.
Specifically says under these circumstances, a Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, special prosecutor Cosgrove, is specially appointed.
Not
to
a judge
Kearney's
anymore.
case. Because of that, I have from the beginning kept a very strong line of separation between both Mr. Kearney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket. And so what I learned is from my public reading and from watching hearings. And so what I know is that there are 2 phones that were searched by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Kearney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Kearney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name.
It's Natalie. It's Natalie. I knew this was what he was going for because he already has Karen's phone and he has her parents' phones. He has everyone's phones.
May be, but I don't know that. And that's why I've refrained.
Let me ask you this, Counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
How do you understand that it has? They've been dicking around about a taint team for 2 years or something like that. Okay. And if you haven't been in communication with them about it because you wanted to go about this the right way, like you're trying to make the worldwide audience believe, how can you stand in court and make these representations? That is Judge Doolin, right? Here's the thing for you, those of you just tuning in. This is a diversion from your regularly scheduled program. Instead of the hearing starting in front of Judge Kearney this morning, there is a hearing now in front of Judge Doolin because Brennan is a dirtbag and he is now, I don't even think he made a motion because I couldn't even find this in the court docket. Aidan Kearney and Karen Reed are sitting at the defense table together this morning in front of Judge Doolin because Brennan wants to intervene in Aidan Kearney's criminal cases to get his cell phone extractions. We went over that motion. He made it in Karen Reed's case, and somebody with a brain probably told him, hey, you're going to have to go make this in front of Aidan's judge. Yes, I'm not going to let you listen. I'm explaining to people, okay? So if you don't like it, please go somewhere else. No, I'm not going to do this later. I'm doing this the way I do it. Again, stop telling me how to run my channel. And this is his argument, even though he said he's not been in contact with them at all. Now he says he doesn't even know if the cell phone extraction has been done. And we know, because we've been following Aidan's case, that the cell phone extractions have not been done. Only one of them may have been done.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show separately and in Mr. Kearney's phone is that there was a relationship between Karen Reed and Mr. Kearney in which Ms. Reed would provide information indirectly and directly to Mr. Kearney. That information would then be reviewed by Mr. Kearney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Kearney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Kearney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle.
Oh, good. He's struggling. I love this.
So the case law says
It's not Doolin. I forget. Is this
the party
Krupp?
seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
Right. He wants Natalie.
I'm not clear on your question, Your Honor.
Really?
How
Because
is
you're looking for
anything beyond
Natalie.
communications between Mr. Kearney?
The judge is asking excellent questions. If anybody knows exactly who this judge is, let me know. I don't know if I guess it's not Judge Doolin. It could be Judge Krupp. It's not Krupp. You guys are local, you know. Here's what the judge is saying. You're looking for communications between Aidan Kearney and Natalie the German, who you don't even know what her name is. You have to show that these communications, first of all, that they exist, and that and don't those communications need to be between Karen and Aidan for them to be relevant? Like, you're really on a fishing expedition here, Brennan, and we're sorry you weren't here for the first hearing or the first trial, but perhaps you should pay attention, at least in evidence class. Listen. And he doesn't know the answer to this, of course.
Consciousness of guilt. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant.
Look at Brennan's
It
face.
calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023. 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So
Enter AJ, Yannetti, Little, and Karen Reed all in a row walking in on this hearing. I can't believe they weren't there for the beginning of it. Were they in the wrong courtroom? Because they were initially told this was supposed to be in courtroom 1. This is the little courtroom where Judge Kearney is. They're doing this ex parte. Look at Yannetti's face. My pause game is on point this morning. And this judge is giving Brennan a public spanking. You want 7 months of data from Mr. Kearney's phone that could include everything from his calendar reminders to his text messages with his kids, and this intermediary or interceder or whatever you're calling her, Natalie the German, whose name you do not even know, to show Karen Reed's consciousness of guilt. Exactly how is that relevant, Mr. Brennan? And he is going to stutter. I got to watch this walk in again. I don't care if some of you do not like me talking or rewinding. That's too bad. I'm not playing today.
messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023. 7 months of material that ostensibly could include everything from
Here's the walk-in.
meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so
Oh.
I'm asking that Mr. Kearney as an attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're.
Can you state your name for the record,
Of
please?
course, I'm sorry. Alan Jackson on behalf of. We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Kearney, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the
This
issue
meeting is being
Counsel.
recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay,
That's correct.
then she needed to be here and she has a right to counsel, and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically.
It was filed under her case number. Brennan's the idiot. He did not file this motion under Aidan's case number. He filed it under Karen Reed's case number. Whether she has a right to be heard or not is irrelevant. She certainly has a right to be in the room. This is wild. Remember the Rule 17 motions in Karen's original case where they were looking for like Brian Albert's cell phone records and Brian Albert's attorney was in there? This is wild. I can't even believe they started this hearing without them being in the room. And then they did the dirty switch of the rooms. This looks like Canoni's courtroom because look at the weird setup. This looks like courtroom 25 to me. I didn't expect to start the morning off so wildly. So let's just take that back a few seconds to listen to Alan Jackson again. He's like, what standing do you have?
Yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, et cetera.
Those are evidentiary issues, counsel,
Correct, but we.
which can be dealt with at a later time. Those are what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case.
Ex parte.
The evidentiary issue will be dealt with at a later time.
I
This
understand,
is
Your Honor, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or the admissibility standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're
And
prepared.
did you give the court notice of that?
We did to Justice Kearney.
Okay.
They haven't been notified of this hearing.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, of the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Radel is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally. The council wants to join in my file. That's an issue in terms of the file.
Yeah.
So, just put it
Thank you. Thank you,
Well,
Attorney
Your
Brennan.
Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion.
Okay, if they don't have standing for this motion, Brennan, why did you file it under the Commonwealth versus Karen Reed case number? This is bullshit to the highest level. I don't curse usually, and that's not even, whatever. This is bullshit to the highest level. You do not file a motion under the Commonwealth versus Karen Reed trial, get a sneaky ex parte hearing that Bradel and Aidan Kearney didn't even know about until something like 10 p.m. last night that was happening, because otherwise you would have just done it without them. Apparently Bradel did put in opposition for Aidan Kearney because they're trying to get his cell phone records to get communications between him and this intermediary, Natalie, who pretended to be a friend of Karen's that Karen was using through Signal to message Aidan to give him publicly filed documents so that he could report on it, which is completely legal, by the way. And now in marches Karen Reed's defense team and Karen Reed and comes and sits down at the defense table like, what is going on here without us? And now Brennan is objecting. And Alan Jackson said, by the way, I'll just be a little mouse and sit over here. Like, that's impossible. He can't be a little mouse. If I was sitting in that courtroom, I would be screaming. Like, I can't be a little mouse sitting here at my own table. Imagine your client. And this slime ball is trying to go behind your back to get these records and don't even notice you of this hearing. This is Chinatown, Jake. This is Chinatown. This is wild. Wow, what a morning. Happy Thursday, everyone. And Brennan's got an objection. Do you remember yesterday or the day before when Brennan said, oh, we have a hearing today. We have a hearing this afternoon. Like, we have a hearing this afternoon. When Aidan Kearney was appearing in Stoughton, being arraigned on these new charges of intimidating the window at D&E Pizza, which is another witness intimidation felony. And Hank Brennan must have been sure that they were going to revoke Aidan Kearney's bail and throw him back in the clink. But in that case, the judge said, you can't even make a motion right now to revoke his bail because you should have done that at the first appearance in front of Judge Doolin and you didn't do it. So basically you waived it. That's what he said to Cosgrove. That day, now that I think back, Brennan must have thought Aidan Kearney's bail is getting revoked. We're going to get what we want. We're going to get him back in jail. It didn't work out that way. And now here they are today. Like, we have a hearing in another courtroom. And this was the hearing that he didn't tell anyone about. This is insane. So dirty. All right. Let's see if Alan Jackson can be a little mouse in the back of the room.
A third party. She has no privacy interest.
Wait, hold on. He's saying they don't have standing to even object or to even be heard. Listen.
Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel.
That's right.
Concerning the substance of the motion and her
That's right.
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
That's right, Teresa. This is trial. This
So-
is what you call trial by ambush.
ADA Brennan, with the court's apologies
First
for
himself.
the interruptions. The crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and have identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder.
Yeah, in Aidan Kearney's case, you dumbass. Not in Karen Reed's case. You're now coming in front of this judge on Karen Reed's case, making a Rule 17 motion. This is the definition of fishing expedition.
Murder of John O'Keefe to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, it's Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek.
My head's gonna pop off.
And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night
Here he
before.
goes.
There are
Documentary.
admissions-
Let me explain to you what he's trying to do. He's trying to get a reporter's phone to look for communications between Aidan Kearney and Natalie to prove Karen Reed's consciousness of guilt with regard to witness intimidation, so that he can backdoor in the witness intimidation in the Karen Reed case. He was stupid enough to make this motion in the Karen Reed case under the Karen Reed index number and not the Aidan Kearney index number. And then they somehow set up this secret hearing, and the judge was, at first, when the army came marching in, the Saints came marching in, Alan Jackson, David Yannetti, Liza Little, and Karen Reed came marching in. I feel like the Rocky theme should be playing in the background right now. At first, he wasn't going to let them sit at defense table, but then he reversed himself and he's like, okay, you know what? You can sit here. We know from the Aidan Kearney case that we don't even know if these phones were ever really searched. We don't even know if a team was ever really involved. There's been lie upon lie upon lie by Cosgrove in that case. We don't even really know the answer to that, and neither does he. He's a slime ball. And now he's going to talk about the documentary? Like that has anything to do with anything? He is so far afield and so out of his league here that I can't wait to see what happens next. So I'll shut up now.
I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested.
Oh, he's going to play a clip from the documentary.
Great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
Does he have
I
a
don't think
setup?
that's necessary, so I'll decline respectfully the offer. ADA Brennan, thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, and inevitably the obvious consequence to witnesses, this is relevant to conscience of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials will be provided to Judge Kearney in a motion in limine regarding conscience of guilt. Also, we'll dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Kearney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
What? Don't cut off the signal. What? Hold on.
Counsel.
Thank you very much, Your Honor. Good morning, Your Honor,
Good
counsel.
morning.
Judge, this is a
Is there bad weather in Dedham today? The signal is crap. It's not us, it's them. Here comes Tim Bradle in his finest suit. Looking sharp this morning. Aidan Kearney sitting next to him if you're driving and you're not watching, with the entire defense team next to Aidan. Alan, Karen, Liza, Alessi, and Yannetti.
Lampron request is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning it has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back.
Did you see how the closed captionings said spelled fishing, like fish, the band? A general fishing expedition, PHISHING. If you know, you know.
Expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there, And then they went to the lowest hanging
You,
fruit.
not me. When you say you, not me.
Right,
counsel.
not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of, not even so much representing Mr. Kearney, but just as a constitutionalist, as a person interested in the Constitution, as an attorney, I saw this, I read the search warrant, out of the Herald or something. And I was prompted to write this press release that I sent out about this exact issue. And I went back to it, I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it. We have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants and talk to anyone she wants and communicate with anyone she wants and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aidan Kearney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and fail. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong. The government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Kearney and conscious guilt, unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person and let's get them off of this and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Kearney's phones. We're not concerned about what's in Mr. Kearney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to put onto.
Let's take this back, Piccadilly Songbird. If you are ahead in another stream, please do not put spoilers in the chat. It's just typical. It's very, very common YouTube etiquette not to do that. So if you know how this is going to end, please do not spoil it for everyone who is watching it together. I want to see if he got a note passed to him. So we're going to rewind it. Oh, he's sitting in the front at that table. Okay, let's see.
Let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Kearney's phones. We're not concerned about what's in Mr. Kearney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to put onto, graft onto any communications in our client's phone, in my client's phone, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations are don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right when to say that, oh, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Kearney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of...
Counsel, what's the legal import of the pending motion to dismiss in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure.
He's asking the right questions. There are motions to dismiss in both cases, in the Karen Reed case and in the Aidan Kearney case. A real judge, yeah, a real judge.
So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Kearney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation and it's the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is what from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in ADA, Special ADA Cosgrove's possession, custody, control. It's already been seized. ADA Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never should have happened.
That issue isn't before me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant.
Right. What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor. That just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for
He misspoke. He said Cosgrove instead of Brennan, but that's okay. I'll forgive him.
the taint team to scrutinize the phones for, we're going to ask for husband-wife
Counsel,
communication.
you're not asking.
No, not you, just so you know what's out there. I just want you to know what's out there.
I understand.
We're asking for husband-wife communications, we're asking for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, ADA Brennan, before I hear from you any further in response, I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Little, Your Honor.
Thank you, Your Honor. Elizabeth Little appearing on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look.
Attorney Bradle.
Oh, she said Cosgrove. She meant Brennan.
Attorney Bradle. Apologies, Your Honor.
Bradle.
It's a lot of
There are.
Oh, now she's going to get nervous.
Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that the grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. ADA Brennan, I'll hear from you in response briefly.
Derp is right. Aidan's attorneys are not gagged. Bradle may speak after this. I was just
I think
thinking that.
most importantly, the
Thank you.
parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradle. It is this reflective of consciousness of guilt? And
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless.
that is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses.
Hold on. That's not entirely accurate, he's saying. We heard him say this at the hearing. I've listened to this hearing about 4 times because I wanted to see every other law tuber's reaction to it. He said that he was not going to use any of this harassment evidence during his case in chief. He did not intend to allow any of it in. He was hoping that both sides could agree that neither of them would let any of the harassment, the witness intimidation harassment information in. And he talked about Jennifer McCabe, and he went on his whole rant about accusing Alan Jackson of bashing the witnesses and saying things that were fraudulent. And I even wrote some things down, but I don't know where those notes are right now. He can't keep up with his own lies. He can't. And now this judge is calling him out on it, and he's going to try and backpedal and weasel his way out of it. He's a weasel. He actually looks like a weasel. I'll allow it. Boss baby emojis all over the place. I will allow it. He's a weasel. I'm rewinding this because it's important and you need to hear it again. What the judge is asking him. It was just the day before yesterday. That's right, Magnolia Gypsy. It was Tuesday. Today's Thursday. It was Tuesday. Talk about candor to the court. And then now he's going to say this is not entirely accurate. Look at what the closed caption says. Proud to burrito. Okay, here we go.
He complains of the concerns of the personal opinions, the constitutional prowess of Mr. Brado. It is this reflective of consciousness of guilt? And
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion, there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
that is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a consciousness of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The consciousness of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know.
But you're looking for communications between Aidan and Natalie. How does that show Karen's consciousness of guilt? It doesn't. You are so far afield here that it's kind of getting embarrassing at this point. We know what? Let's see what he says. We know.
To try to cover for the crimes that she's alleged to have committed. We know she was providing information, even protected information to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on condition of witness or not, felt very intimidated. We know the mental anguish they suffered. The defendant, in our case, Ms. Reed, knows it as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it.
Back to the documentary.
And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Kearney if appropriate, and then she should decide the admissibility in the Commonwealth v. Karen Reed trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
Wow.
It's been warned. Yes, and my teenage kids dinner. Yes.
Okay, I don't know what the hell just happened there, but Long Crime must have been moving on to something else. Now, I guess we're going to have to wait for the Judge Kearney hearing. She's on the bench, so we can flip over to NBC 10 for that. That was wild. For those of you who joined late or maybe had no idea what was going on, this is not on the court docket today. I have the court docket up for today, every case today in Norfolk Superior. This is not on the docket, so I don't even know how anybody found out about this case, this hearing being on. This was in front of a judge that we're not even sure who it was. Brennan tried to backdoor his way into his Rule 17 motion for Aidan Kearney's phones that he made in Karen Reed's case by having a different judge hear that motion. And it must have been just the judge who was sitting in that part today. And Brennan was making all kinds of arguments that he needs Aidan Kearney's phones for the communications between Aidan Kearney and the intermediary, Natalie, to show Karen's consciousness of guilt, as they are highly relevant in the Karen Reed case. And that was wild. If you weren't here for it, I suggest you rewind it and watch it later, because it is unlike anything that we've ever seen. I don't even know how this, how the attorneys were even given notice of this hearing. And then Hank Brennan started screaming when Alan Jackson and Karen's team started walking in, saying they shouldn't even be allowed to be there. This is just insane. And now the Judge Kearney hearing is going to start in the same courtroom. And that judge took it under advisement about whether or not they're going to give up the communications. So he called it a fishing expedition. Bradel did anyway. This is wild. We go back into Judge Kearney's courtroom for the actual hearing that we thought we were going to be here today for. The Karen Reed hearing.
117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Barbara Boston for the Commonwealth. Good morning, Mr. Boston.
Adam for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right. So
I'd just like to point out, Mr. Lally has his shark fin hairdo back today. Baby shark hairdo, bubble bath, baby shark. It's back. I don't know what product he uses, but the day I never thought there would be a day where I would say I miss Adam Lally, because at least he wasn't a mean-spirited, dirty player. He was just not so smart, in my opinion. This is next level.
we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read.
Of course, she needs a break.
What I'd like to start with, it's paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3. And we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
All three indictments, correct? You're defending all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice. And we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance. And I'll submit.
All right. Does the Commonwealth want to be heard on this?
Of course they do. How's your morning
Your Honor,
going, Hank?
The Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different, but most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion.
Of course she's
All right?
not.
We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches. And we'll take it from there, but we will start April 1st with impanelment.
Oh, she took my advice. I
right,
said,
so let's
I
go.
said, we don't always pick and go in New York. Sometimes we pick and we tell the jury to come back for a later date and we suss it out during jury selection. And we tell them, all right, we're picking the jury now, but the trial's not going to start until this date. Will you be available? And it often works. Does she really think they are not going to be able to pick a jury before April 25th? And then she'll hear the motion again. How about all the pretrial prep that needs to go into this? And for Hank to get up there and say, oh, yeah, I can understand how it might be a little bit different if they're prepping for a murder case or a manslaughter case. Are you kidding me, dude? You are by trade a criminal defense attorney who has represented mobsters among many other criminal defendants. You can stand up there with a straight face and say, well, it's kind of different. It is 100% different. Mark Betterow was on with me last night. If you didn't watch that show, go back and watch it. It was great. Completely different trial prep. So now they don't know what they're prepping for. They don't know if it's a manslaughter case or if it's a murder case. We had thoughts yesterday that Hank might be intending all along to drop the murder charges because of the things that he said, that he is not going to call the Aruba sisters. And that was his whole motive in the last trial, right? His motive for the last trial for Karen wanting to kill John was the jealousy that she felt from that Aruba incident a month earlier, where she walked into the lobby and Marietta Sullivan, who said that Karen sucks, may or may not have been making out with John. So this is all insane. She's not going to grant them the adjournment. And good morning, everyone. Good morning. Happy Thursday.
Go to the next motion and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
Not only do they want a buffer zone extension, they want the law enforcement to be able to use reasonable force to arrest anyone that squeaks by that buffer zone or anyone who wears any clothing that may say Free Karen Reed or Justice for John O'Keefe on it. Welcome to North Korea.
I have it here somewhere. I'll find it. So we did hear from people this morning. I know you all have, I have it. I have it, Jim. I think Mr. McDermott gave you a copy of, I guess, what local merchants have requested.
Thank you, Lori Live 360 for gifting 5. Love you.
All right, so I'll hear the Commonwealth on your buffer zone motion.
Reasonable force. Take them down with tear gas. Get the tear gas out. Bring the tanks in, Hank. Hank, the septic tank. Somebody called him
Your
yesterday.
Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned based on past reports and information that noise interruption and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence to the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so
Sounds like
influencing
some
their
merchants
business as a separate but related concern.
merchants in the area have filed some papers. We haven't seen them. I don't even know if they've hit the docket yet. But maybe they're saying, listen, if you put us within the buffer zone, none of the people that are gonna would come and have maybe a slice of pizza would able to get to us in their free Karen Reed shirts. So we oppose this. I don't know, because he doesn't know Dedham very well, so he doesn't know what they're talking about. But we haven't seen those papers.
Concern that they have expressed to the court, and I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence in the jury, I think, can affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing or
Yeah, reasonable force.
enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right. With that, does the defense object to the buffer zone?
We take that position.
Okay. All right. I'll take this under advisement. I have to figure out exactly how far this is. And I have not yet had a chance to read and consider today's email from the merchants. Okay.
What's the over under on whether she'll decide anything from the bench today?
Can I just have this marked for identification for this hearing? Identification. And from the record, that came from the Dedham Square Circle, the organization that runs the Dedham Farmers Market.
The Dedham Square Circle Farmers Market has opposition.
We can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyways. All right.
Thanks, Kyle.
Your Honor, can I be heard on that one issue, just briefly?
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. it's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
Oh, we gave it to them, but they didn't give it to us, Judge.
So there is a
Spank
footnote.
him.
I'll hear you, Mr. Brennan.
Why don't you spank him? Thanks, Tricia.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses.
Wow.
Which the Commonwealth believes is ongoing.
Wow.
I think a potential.
So you think that the Karen Reed's team is going to leak Aidan Kearney the addresses of your witnesses so that he can go intimidate them? That's rich. That is rich. Let's see. Will the judge let Hank be exempt from this requirement that he turn over the addresses of his witnesses and their phone numbers? Mm-hmm.
Past history of perceived harassment and intimidation of witnesses.
Has nothing to do with
which the
Karen.
Commonwealth believes is ongoing. I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from.
I don't have a problem with that. I still need cities and towns.
That's what Ms. Little just did.
Okay.
Yes.
She already did it. You didn't do it at all.
All right.
It's another non-opposition opposition.
Thank you. So we will start with it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminate to allow evidence of lack of bias. Who's arguing that for the Commonwealth?
This has to do with ARCA.
Oh, it's defendant's motion.
This has to
The
do with
Commonwealth opposed it.
this has to do with ARCA.
You had asked who's arguing that for the Commonwealth. That's why
I'm
I
sorry,
didn't-
defense motion.
Okay,
Okay,
that's fine.
sorry, I apologize.
I
This has to do with letting the jury be told that ARCA was initially hired by the U.S. Attorney's Office because they were confused during the last trial.
Could go first if you'd like.
Excuse me?
I could go first if you'd like.
Shut
whatever-
I'm fine with him going first if you'd like.
Okay.
He's such a brown nose, Hank Brennan. He's such a brown nose. Thank you, my nurse, Cal.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report. And then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know
He has zero evidence of this. He just gets up in open court and spews nonsense. You know what we will never know? We will never know the true relationship between the Norfolk County District Attorney's Office, Michael Marcy, Mr. Lally, and yourself, between the relationship between you and the Alberts and the McCabe's. We will never know the true depths of that relationship, but based on the hostage video from August of 2023, we can kind of take a little guess. Based on the fact that you had Tully call in Jennifer McCabe to prep her for trial, and while she and apparently her husband were there, You allowed them to watch video, listen to 911 calls, read their grand jury transcripts. You want to talk about relationships that we're never going to know about? Let's talk about that. But do not get up in open court and accuse the defense attorneys of colluding with the U.S. Attorney's Office with zero evidence to back that up. Really, dude? Really? I have to take it back a second. That's not how federal investigations work. David Dinetti doesn't pick up the phone and say, hey, feds, I got something for you. You want to investigate this?
Stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case.
What proof of that do you have? You have no proof that they gave the government any information. You have no proof of that. What we do know is that the defense gave the federal government information. Hold on.
Including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case.
How do you know that?
What we know is that the defense.
Where's the proof of that? What we do know is that Michael Marcy wrote crazy letters to the feds asking them what they knew and that they had Brady obligations to turn it over. What proof does he have of this? I can't wait to hear Yannetti spank him publicly after this.
Had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials.
Supposedly. They were supposedly.
We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is a undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed.
If you don't know, then why are you saying this as if it's facts? If you don't know, why are you saying this as a factual statement? He never has any proof or files or paperwork. It's crazy town. Thank you, Juan Yogi, for pointing out what I was trying to say.
That came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts and report was wholly and entirely objective. Just to give one point that emphasizes the concern. The ARCA witnesses were never given information about DNA. And yet, when they testified, one of the witnesses tried to
It
address
doesn't
the issue
matter.
of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was.
Touch DNA?
There was DNA, and separately, there was a hair, Mr. O'Keefe's hair.
Was
And
there
so
blood?
we know
Was
they
there
didn't
blood?
have
Was
all
there
the
skin
inculpatory
tissue?
information, and then the question still remains.
Was there blood or skin tissue? Oh, there was touch DNA on the taillight. Anybody know any law enforcement, patrol cops, beat cops who touch taillights as a matter of, I don't know, habit, custom? That's just one example of how touch DNA could have gotten on the taillight. It could have washed the car. He was around the car all the time. She lived with him. And one stray hair that survived in a blizzard, driving 40 miles to Dighton and then being towed back 40 miles in a blizzard. There's one stray hair. Was there any skin tissue? Was there any blood? Anything on the undercarriage of the car? Anything? Any blood inside the No, no. The ARCA witnesses didn't need that information because it wouldn't change their opinion that John O'Keefe was not hit by a car. Sir? They're biomechanical engineers because physics. This is such a weak argument. I'm going to take it back a second.
That there was no impact between the. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately, there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate
Because here's how they learned. Here's how they learned. And you could have asked them that on cross-examination, or Lally could have. We know that you weren't at the last trial because you keep reminding us how much better of a job you would have done than Lally. But here's how they knew. Because expert witnesses are permitted to watch the testimony of other expert witnesses, which they could have watched from the comfort of their own home or office on such channels as Court TV or Law and Crime. So before you thinking there's something nefarious going on, like the defense attorneys prepping them for their testimony, think about the obvious. Think about the obvious, Hank. We don't know how they found that out. Come on, man.
Decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls.
Did you put that in your papers? Did you put it in your papers?
Text messages.
That you want them to come in and answer all of these questions in front of God and the judge and the world? Did you put that in your papers? Because I don't remember reading that in your papers. Thank you, Suze. That was Adam Sisitsky, the judge. And thank you, Emma. Thank you very much. Of course not. He doesn't put anything in his papers. He just gets up and says whatever he wants. He's just like diarrhea of the mouth.
Messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned as they should well before trial, in my opinion, we do not have the opportunity to question the United States Attorney's Office. We resigned to TUI letters, which inevitably have been unhelpful. And so
It's so funny that he says that.
A bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would like to propose.
How do you know that the investigation's been closed? Because Canton Police Chief Helena Rafferty put out a statement on her letterhead. There has been no official announcement from the U.S. Attorney's Office. They've said consistently we cannot comment on investigations. And so again, here he is spewing untruths, mistruths, lies, and blatant misrepresentations in court. And where's the grave concern from the judge now? Where is her grave concern of candor to the tribunal and candor to the court and deliberate false misrepresentations that he is making now, because he's now saying these TUI letters are worthless, when he got up in an open court and was waving those papers around in front of the judge that caused her to have a near stroke with her shaking and called the day short with her grave concerns because he waved around the papers and said he got them from the U.S. Attorney's Office. And that was a lie. He got them from the defense. He is so twisted, so backwards, upside down, inside out, that it's making everyone have an ulcer. Or maybe just me. Maybe you have an ulcer too at this point. I don't know.
And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently. And then subsequent to that, the defense retain them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
Okay, so
And we still don't know why the defense chose to call 2 of 3. As you noted, that report is vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me.
Did you go back and watch the voir dire from the last trial of Dr. Rentschler and Dr. Wolf? Because they were specifically asked who did what, and it was all there. It's all there for you to go back and read the transcript. Remember how she said to Mr. Jackson the other day, go read the transcript? Is she going to tell him to go read the transcript? In my dreams.
Me to imagine how you would choose 2 of 3 of those witnesses, but more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will.
Maybe you better put it in
My
your papers.
suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just ask them the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Based on their past performances, that's insufficient. Oh, please, David, go, David, go. Misty and Eddie. He's my favorite. Don't tell the others.
Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate,
And,
right?
but the point of the fact of the matter is, Your Honor, they did speculate. They at least.
And also the reason for Karen not being acquitted of counts 1 and 3 is because your instructions were so messed up and so confusing and so blatantly wrong that we are now having to undergo a second trial on counts 1 and 3 because of your instructions. So they didn't even understand reasonable doubt, apparently. And they did speculate. We know that now because the jurors have spoken out. And they said, well, we didn't know who hired ARCA, so we just thought it was either Karen's insurance company or car insurance company or Turtle Boy. And so we just disregarded it.
Fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal...
She's already telling us how she's going to rule. If I allow, and I'd be very surprised if I did. Oh, Auntie Bev, your bias is showing again. The world is watching, babe. The world is watching. What are you doing? Listen.
If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal... how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now and then I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh,
If-
you just
if
said
I
it's
can-
late. Hold on. You just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
Is it so out of the realm of possibility to allow these attorneys who have their arguments in some sort of logical fashion, unlike your boy Brennan there, to make their argument and their oral argument and their presentation in the order in which they have written it that makes the most sense, that is chronological, and she just really had to have a fight with him in open court? I'm embarrassed. I have secondhand embarrassment for her. Look at Aidan's face. I'm gonna play that again. If you people, whoever is out there that's gonna complain that I'm rewinding and talking too much, please go watch it on Law and Crime, and good luck surviving over there in the chat. I am so outraged by this. I'm rewinding it. How dare she? How dare she?
If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal... how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now and then I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh,
If-
you just
if
said
I
it's
can-
late. Hold on. You just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
Okay.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my client's, to prejudice my client. thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government.
That's
and
new
I
information.
complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA. And they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with. And all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes.
Of course. He always has to get the last word. You notice that?
Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Iannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how.
Perhaps the Commonwealth knew, but I never heard that before. Do you remember one day when the judge made it, every defense attorney stand up like they were in the principal's office and say, you understand that when you speak, you're speaking for the entire defense team, and that if you know something, it's imputed to the rest of the defense team. You just said, I don't know if the Commonwealth knows that. Shouldn't you know? Aren't you getting paid to know? Remember how they said they were going to give him $75,000 in a contract for the entire thing at $250 an hour, and now it's been exposed that he's already been paid something like $250,000? You are paid to know. So before you get up there and make an ass out of yourself again today, maybe you ought to just ask Mr. Lally, did we know that? I know that he's sandbagging you. I really believe that. But I also believe that maybe Laura McLaughlin has a lot more to do with this than we know. Maybe you should ask Ms. McLaughlin. Did we know about that? Did they subpoena our file too? Because they probably did. They probably subpoenaed files from both of them. Listen, again.
And what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before.
Ignorance is no
I don't know
excuse.
how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence, so we were hiding from the truth. We weren't invited. We didn't know.
You didn't choose to hide from exculpatory evidence, like hiding all of the Sallyport video until like a week ago, turning over one inverted video and not even telling the jury and the world that it was inverted until it was brought out on cross-examination. And then you hide all of the Sallyport video until after the trial when you start turning it over in dribs and drabs. Sergeant DGM Pietro of Canton PD, who, by the way, was conflicted out of this case, apparently downloaded all the Sallyport video and then retired something like 2 days after your October of 2024 dumping of that Sallyport video. And you continue every day to turn over more and more and more. And you say that you're not choosing to hide from exculpatory evidence. No, you're not choosing to. You are deliberately concealing, altering, hiding, destroying, and altering exculpatory information and video, sir, in my opinion, and the opinion of many other video experts who have looked at this video and said it's absolutely 100% altered. There's no metadata. Wow, this is embarrassing for him. I got to hear that again. We didn't choose to hide exculpatory or run from exculpatory. What?
Their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence, so we were hiding from the truth. We weren't invited.
Hiding from the truth?
We didn't know. Now, I hear now that Mr. Yannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was...
They say what they reviewed.
February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to...
Oh, you absolutely are.
Proper about the relationship.
That's all you do is cast aspersions. Anytime, it's like somebody saying, to be honest with you, they're going to lie to you. I'm not casting aspersions. That is exactly what you are doing. I'm not suggesting that there's anything improper about the relationship. That is exactly what you've been doing all day and other days. Saying that there's an improper relationship between the defense and ARCA. You just said that there's an improper relationship between the defense and the U.S. Attorney's Office, and they were colluding together. This is gaslighting at its finest. This is a masterclass in gaslighting. Hold on.
So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was
Uh,
obviously
That's all you've
a
been
relationship
suggesting.
between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence.
I'm not
I do not
accusing
think
them of
that
perjury or
witness-
anything. I'm just saying, maybe they were a little misleading. This man is really straining my credulity right now. And I apologize if I'm yelling too much for some people. But I am outraged, and you should be too. And look at Kelly Reed's face sitting behind Brennan. Look at Kelly Reed's face. I love Kelly Reed. My freeze game is on point today. She's pissed. That's Karen's mom sitting next to her, and she's pissed too. And Karen Reed could be any one of us. And this is outrageous, and this is disgusting, and this is vile. And this man is a dirty, dirty. This is why people hate lawyers, in my opinion. And I'm not yelling at you, I'm yelling with you. You should be outraged because it could be you sitting in that defense chair going through this for the second time. He's not accusing them of perjury, but maybe just misleading. This is insanity.
Suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is.
He's the police now.
Biased. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. Right?
Oh, let's pay them again to come in. I'm sorry. Is my volume much louder than the court?
We're going to move on.
Lower
I'll
it a
take
little
this
bit.
under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on. And
All right,
I'll
I
hear
turned
any
it down.
objections later.
Is it better now? Hang on. Is my volume better now? All right. Is it better now? So she wants them to come in next week for a voir dire, another voir dire. And, oh, thanks, Brittany. She says it's fine. So it depends on what device you're watching it on, you guys, or if you have headphones in or whatever. She wants them to come back next week for voir dire, so they have to pay them again to come. Thanks, Brittany. And she's not even going to tell them the parameters. But this time, since they are hiring ARCA this time, since their contract is over, they can prep them. But she's not going to tell them what they can prep them on. And also realize that Hank Brennan is taking 100% advantage of the fact that he knows that the defense team is on thin ice because of her public spanking of them the other day. And so he's really getting close to the line. He's already crossed over the line. I'm not even going to be nice about it. He's crossed over the line. And she doesn't want to tell them what the limitations of this next week's voir dire is going to be, because now we're coming back again next week. But no voir dire, right, for the Commonwealth dog whisperer Crosby, right, yep. And the DNA wasn't tested yet because Lally kept it from the defense. Thanks, Anna, for pointing that out. At the time ARCA did their investigation, there was no DNA because Bodie Labs held on to it for how long? I think he turned it over like either right before trial or during trial. Wow. Sorry if I blew your ears out before. Okay.
All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Yes, I believe my written submission essentially makes the argument, Judge, but
Okay.
during the last trial, as a result of our inability to state in, one or two words, the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that, we have a jury sitting for weeks at a time away from their families, away from their jobs, and any, sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was.
None of us
and
did.
The court made a ruling on that objection, and I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
I understand, but what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You
I'm-
should have known the basis for the
Well, I'm hearing it for the first time at sidebar.
She's saying you should have known the basis for the objection. You should be smart enough to know the basis for the objection. The Commonwealth shouldn't have to tell you the basis for the objection. Can you believe she just dissed him like that in open court? The objections that Adam Lally made were so far out of bounds. His objections were based on whatever the witness is going to say next is going to kill my case. It's going to hurt my case. Or the witness would look at Lally like, aren't you going to object and protect me? Or the judge would say, Mr. Lally, do you want to object? And she just said to Mr. Yannetti in open court, who is one of the finest lawyers that I've ever seen, you should have known the basis for the objections. You need to hear that again because that was a dig. You need some shovel emojis in the chat. You should have known. I don't think he's picking up what she's laying down, that he totally insulted her in open court. I mean, that she totally insulted him.
And the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
I understand, but what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know
I
it.
agree with that.
And
You should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no, trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights. And we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied.
Denied. Of course it is.
Motion, defendant's motion, eliminate to exclude false and irrelevant statements of Michael Proctor.
That was a blatant protection of the Commonwealth. I don't know any other jurisdiction that doesn't require grounds for objections. Everything is done at sidebar here. She's insinuating that he should know what the grounds for objections are. This way it preserves everything for appeal. They have to make all of their appellate record at sidebar. And there was a recent case in which it was in Massachusetts that they cited in their papers, the defense did, in which a client's appeal was thwarted because they did not state the grounds for their objections. And so she's insane. Oh, she's just mad Proctor was fired, maybe. It takes so much time to have to go to sidebar for everything in this case, but she doesn't care. But she's all about getting the jury out of there quickly. She only gives the attorneys an hour for their closing statements or closing arguments. And, you know, she's still going to do it her way or the highway. I've missed seeing him argue too, Heather. I agree. Denied.
591, exclude false. So
Oh, here we
the
go.
next motion,
Proctor.
defendant's motion, eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that motion.
All right. So that motion's allowed, Ms. Giannetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Lessie, what I'm going to do with that is if I can readdress that before rebuttal.
No.
Before the witness is called.
No.
So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right. So we can address it later.
Thank you, Your Honor. And
Okay.
also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it after
Thank you.
Dr. Russell's testimony. All right. There's a motion. It's 599. Defendant's
How are they supposed to prepare for trial if they don't know whether or not Crosby's going to be allowed to testify on rebuttal? This is so unfair. It's disgusting. It's officially off the rocker, Sassy Vice. You're right. So we'll hold off on Crosby. I'll let you know at some point, because you should just, prepare for everything and I'll rule on nothing, basically. Oops.
motion eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact.
Yeah, that should be
So-
obvious too.
We don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So
Ipsy Dixit, because she says so. Because she says so. Fanning never had contact with the jury, so we're just supposed to believe her. Okay.
there's that. So I think now we move on to something that may take a little bit more time. The defendant's motion eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alisi says, but I can't imagine it's more than 15 minutes.
His name is Alessi.
All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick
Disrespectful is what he is.
that I just wanted to know if the defense had objections to. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr.
All right, hang on. I have a request to pause the stream. Hang on. Blessed in Texas says, serious question. Please pause to answer. I know others wonder as well, why is the defendant not objecting in real time to outright lies that Hank tells in court? If you're the defendant, how would you handle these lies in front of Bev? I've never been a criminal defense attorney. I don't pretend to be a criminal defense attorney. I am a civil litigator, sued the Catholic Church, among many, many, many other things. However, there's no jury here. There's no reason to object. What they can do is when they get up to make their argument, they can point out the lies that he's telling and they can refute the lies that he's telling. But during motion practice, it is not, an objection wouldn't be proper because there's just no jury there. And so they can argue in their response the things that he said wrong and they can correct him. And I think that they did. And they're standing up for themselves. So that's a great question. That was from, 15 minutes ago, but I hope that answers your question. Thanks for the 20. Appreciate you.
Mr. Brennan.
Thank you. Which motion, Your Honor?
It's your number 1, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
They're also on thin ice. I heard somebody saying that is true as well, but
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors. This case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And
really?
So the jurors,
how about
I
the jurors
suggest,
being
should not-
stared down by the third-party culprits at closings? How about that? Do you think that that might scare the jurors or, influence the jurors by being stared by Colin Albert and Brian Albert during closings? Because some of the jurors actually said that it did. And then you got up in defense of that motion and said that it's a time-honored tradition. It's a time-honored tradition for the witnesses to come in and listen to the closings, and therefore they should be allowed back in. And again, shield and sword. You're worried about the jurors being intimidated with regard to the buffer zone, right? So you want a bigger buffer zone. You want law enforcement to be able to use reasonable force to beat people over the head, apparently, or mace them, or throw tear gas bombs in their direction if they're wearing a free can read shirts. But it's okay that Brian Albert and Colin Albert stare the jury down during closing arguments. We're in the twilight zone. Yes, we are. It's the Hunger Games at this point.
Be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
Any objection from the defense?
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors.
It's your motion,
Sidebar discussions
Dick.
regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion, perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well,
on
that's what I'd
things
like
that-
to
All right,
address.
so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a
This is a new
change.
trial.
This
Judge.
is a
Right,
new-
no, so just to be clear, this is a change.
I don't recall what we did.
This is a new trial, Judge. I'm glad he threw her words right back at her. I'm sorry I was talking. I'm turning it back. Oh, well, you didn't object to it last time. Well, it's a new trial, Judge. You keep saying it's a new trial. Here's the question. Hank wants all of the sidebars impounded. He's pointed out that anybody, you or me, could go out and get an FTR account, which is for the record. It's the recording system that they use, the court reporters in Massachusetts, to, we see Madam Court Reporter talking into what looks like a athletic cup. Anybody apparently can get an FTR account and order the transcripts and listen to the sidebars or hear them, or it's a transcript, I'm not sure which. Brennan wants all of that sealed, and that was in his motion, but apparently he forgot to address that part or forgot that he made it. And now United's going to oppose it, but she said he didn't oppose it last time. Listen. Impounded is like sealed. Thanks, Mac, for that question. We call it just sealed in New York. In Massachusetts, they call it impounded, which would be sealed, not available to the public. In New York, when you have your car impounded, it's because you have too many parking tickets. But in Massachusetts, impounded is just another word for sealed.
Regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well,
on
that's what I'd
things
like
that-
to address.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a
This is a new
change.
trial, Judge.
Right,
I've
no,
been
so
told.
just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet.
That's right. And you know what? You've put a gag order on the defense attorneys, so they're not allowed to talk now. You don't need to run with this in a dirty way, but I just want to point out that between Tuesday's hearing and today, both lubricant and prophylactic has been brought into the chat by the defense attorneys. And yes, we are talking about it on the internet. I think I'm going to go get myself an FTR account right now after we're done here. So there's that. There are commenters who write and speak about this now. And you know what? Now we're the only ones who are allowed to speak about it because you've already gagged all the attorneys. And so we are here to talk about how insane this is and how crazy this is and how Karen Read is being railroaded in a kangaroo. What is lower than a kangaroo court? Oh, that was an open season to put dirty words in the chat. Thanks. Just thought I would point it out. We try and keep it clean and classy here. We try. You can talk in code. Listen.
Can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment, covering all arguments made at sidebar, would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
Watch what she's going to do.
So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
Mr. Brennan, do you know the law? He's like, oh, somebody quick. He should have an earpiece in so somebody can quickly go to Westlaw and find him a case.
I don't have an answer to that.
Of course you don't.
It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it. I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information.
Really? Are you saying the jury's going to go home and watch my show on YouTube? You don't trust the jury to be able to follow the judge's directions, sir? Is that what you're saying? Again, he's got no objection to the public hearing it, and so therefore she should just allow it without allowing him to go look for a case. Really? He doesn't trust the jury. Too bad, so sad. We want to talk about the sidebars. And look, Pinedon Proctor says, I forgot to tell you the FTR is designed for readbacks. I looked up, right? She didn't allow readbacks during the last trial. But we need to be out here screaming about how these objections are sustained that are insane. And here's the question of the day. Will Judge Kearney say, hey, Judge Gull, hold my white claw. Check this out. You think your rulings were bad? Watch me. I'm going in. It's a Delphi reference for those of you who don't know.
Whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial.
Stifle the First Amendment? It's not stifle. Stifle does he mean stifle? He calls incisors incisors. This man just seems to need some sort of pronunciation app. Stifle the First Amendment? This is where we get to laugh because otherwise we're just going to keep screaming and crying. So we're just for the comedy of it. Hear that again.
If the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately.
Oh my God, was that a
that
nod to Yellow
creates-
Cottage cheese? It's a cottage industry. Was that a nod to Yellow Cottage cheese, his spokesperson who goes on court TV for his talking points? Was that a little Freudian slip? Listen, his voice is AI generated. Hold on. YouTube is a cottage industry. Remember the day that Kevin Reddington mentioned me in court as being a credible source on the YouTube in the Turk trial, which is starting next week? Jennifer McCabe's head probably popped off because Kevin Reddington was Jennifer McCabe's attorney. Cottage industry. You know what? Mainstream media is dead, Mr. Brennan. So your mouthpiece, I mean, Christina Rex may or may not be his mouthpiece. I'm not really sure, but she seems to post on Twitter documents that have not been scanned into the court docket yet. And then she tweets about them. So maybe she's your mouthpiece, maybe not. I'm not really sure. That's just my own personal opinion. And people have pointed that out to me. And I don't know if it's true or not. It's just, interesting that you would say such a thing. You don't want to deprive the community of the full value of the public trial? No, that's exactly what you're doing.
Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court whether we have that basis or not. But I
No.
can't tell you that now.
You
All
should
right,
have
so
put
I
that
am
in your
taking
motion
a lot of
papers.
these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very
No,
much.
Stifler's mom. That's what he was thinking of. Stifler's mom. You're exactly right. Jennifer Coolidge has entered the chat.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the victim, 1 photograph of the victim, 2 photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to
No
that,
objection.
Ms. Little? That's allowed. 578.
Thank you.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan. Paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate.
Okay, they made this motion before the last trial, and it was denied. No, it was granted. So they couldn't mention the manner of death on the death certificate, which is undetermined. But again, this is a new trial. Let's see what she's going to decide now.
Mr. Brennan, paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate.
But Hank, I thought you wanted the truth. I thought you wanted the truth. And the truth is the medical examiner could not determine that this was a homicide, despite Michael Proctor's best efforts to get her to change it. It still remains on the death certificate. Manner of death is undetermined. For those of you who don't know, there are 5 manners of death that can be included on a death certificate. They are homicide, suicide, accidental, natural, and undetermined. The medical examiner in this case, Irene Scordi-Bello, was not going to be strong-armed by Proctor and DeCicco, and they did hide it from the jury last time. So let's see what they do now.
Certificate. I'll hear you
May I?
on that. Yes.
Pursuant to Mass case law, Commonwealth versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses that are called regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different when questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted and it should follow Massachusetts general laws and it should follow Massachusetts case law. And for those reasons, we ask the court to redact any cause of death in the death certificate itself.
All right, who's arguing this for your defense? Ms. Little?
Thank you, Your Honor.
Go, Liza. Go, Liza. It's your
In this
birthday.
case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues.
Wait, what?
All of the cases cited by the Commonwealth.
Wait, Irene Scorti-Bello is not on the Commonwealth witness list? How did we miss that? I got to go back and look at it, but I'm going to trust Liza because she knows this case better than anyone aside from Karen, I would submit to you. Is Irene Scorti-Bello not on the Commonwealth witness list? Okay, hold on. She's not. Wow, Letteros by Bettero. Thank you. That is so, they're not calling their own medical examiner who did John O'Keefe's autopsy. Wow. That is incredible. Wait, she is on the, I'm going to go back. All right, I'll go back to it, but, oh, she wasn't. I thought you knew. Did we not? I don't remember pointing that out. She's on the defense list, but not, okay, let's let Liza talk. Sorry. I'm sorry for interrupting, but that's wild information that I guess I forgot.
Here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even.
I have the Commonwealth witness list pulled up, and Irene Scorti-Bello is on the Commonwealth witness list. She's listed as number 80 on the, I'm sorry, number 82. She's number 82 on the Commonwealth witness list. And so I don't know if they've said in some other proceeding that they don't intend to call her, but she's on the list. I just checked. Maybe they're not calling her. I don't know. I don't know if they said some other way that they're not calling her, but she's on the list.
True case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw her.
She is.
Dr. Scorti-Bello?
Yes. Oh, Liza. Guys, pull it up.
Not on their witness list.
She is. I have it right here. Oh. It's docket number 603, and she is number 82 on the list. I'm looking right at it.
She's number 81 on the Commonwealth's witness list.
82. Laura McLaughlin. 81 is Justin Rice. I'm looking at it.
All right. I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize. I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner. So that was my.
Okay, better. Better.
Perhaps
Thank you.
I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the Registry of Motor Vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay. Probably one more quick. So that's paper 580, Jim?
Thank you.
Commonwealth's motion to eliminate with the intent to obtain Corey records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that? Elaine?
Sure.
Oop, they want criminal history record run on
Your
all
Honor,
the
potential
jurors.
jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire, precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. Does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means,
Thank you, Nathaniel Brown, for gifting 5 memberships. Appreciate you.
Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
He finally asked Lally, is this the common practice of this office? Chicken coops and counter coops. Well done on the username. He asked Lally a question. Do you think Lally gave him the right answer?
Your Honor, is the court's question common practice of giving everything, or is it common practice of running queries?
It actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, maybe people who have a criminal record in re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. I understand may have happened in this case, has happened in many of my cases, and the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all too to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up. And I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial there's somebody that says they forgot to say something, or they had a record that, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're
But I
giving the
thought-
jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay.
Guess
All
we
right,
know what
why
she's
don't we
going to do
take the
there.
morning break at this time, and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
Yeah, we'll do that motion. What a morning. Is that somebody said Coffindoffer? No, that's not. That's the crazy ex-girlfriend right there from the documentary. Her name's like Tara, something Irish, and she wears like John O'Keefe's badge number necklace around her neck. And I don't think Coffindoffer is there, but you guys can tell me if you saw her. That's Tara something. She, broke up. John broke up with her like 25 years ago, and he's like the one who got away. And she's like Tara Kerrigan. That's what it is. She's on every documentary, and I'm not doxing her because she's been on all the documentaries. Every time she can get her face on camera, she's right there. Is Sally Jesse Raphael sitting in the press box? I don't know. I didn't see that. Hold on, let's go and see if we can fast forward through the break, because we may be able to catch up to yeah. Okay, so there's that. Let's just look at some of the questions on the super chats before we move on, because there's a lot of questions here and good comments. So let's take a look. IMG NYC says, I feel like old Bev and Hanky went to ex parte on this. We're talking about the hearing from this morning. If you weren't here, it was wild. Brennan is trying to intervene into Aidan Kearney's case. Go back and watch that later, and looking for his phone records. And the judge gave him a little bit of a spanking. That was fun. I feel like old Bev and Hanky went ex parte on this, not granting Betterow pro hoc suddenly makes a whole lot of sense. Yep. Thoughts. Absolutely. Absolutely it does. I think they knew this was coming, and they're like, oh, well, they're going to want to get Aidan's phone records, and they're going to want to pit them against each other, and therefore conflict. Thanks for keeping us in the know. Thank you for your super chat. I appreciate you so much. Romy, thanks for the 20 for thanking me. I appreciate you, Romy, more than you know. Lori Lake says, please rewind, replay, and rejoice when we hear smart people say smart things and make stupid people look stupid. Thank you, Lori from Canada. Appreciate you always. Karen says, Hank isn't in Judge Cannoni's court anymore. That was from this morning. A friend of the devil is a friend of Hank. And I always do love a good Grateful Dead reference. Thank you. Motions in CPA. Does the no bill on their grand jury to link Reed to Kearney improve or influence, maybe you want to say, the judge's decision? I don't know how it could have zero weight. I agree with you. We'll see what this judge does with regard to this. Cynthia, Brennan's just protecting a different mob now, the McAlberts. This is disgusting. You're not alone, Cynthia. You are not alone. Thank you. Edward, can the grand jury no true bill be brought up to help stop this expedition, since he keeps trying to get consciousness of guilt for the grand jury rejected things? It would not be allowed to be brought up in Karen Reed's case, but I don't know if this was from maybe this morning. And I think they did bring it up, right, during that hearing of trying to get Aidan's records in front of another judge. And then that judge reversed himself and finally allowed the defense team to sit at the defense table with Tim Bradel. And Betterow was not there today because this was apparently just put on the calendar last night. And when I look at today's docket for the Norfolk Superior Court, it's not even on the docket. It's not on today's calendar. So were they trying to do it in secret? I have no idea. But we found out about it because Aidan tweeted about it last night near 10 o'clock p.m. Piney Woods loves being here. And Hank had already made her crazy by 8:30. Thank you so much. Now we know why they have slow walked the extraction on Aidan's phone, says Reed's bite is bigger than Chloe's. Now we know why they have slow walked the extractions on Aidan's phone and why they have not turned them back over. This plan was in place all along. Yep. I think you're right. Aussie Steve is here. So glad he stayed up in Australia to watch Brennan screw up so badly. He's crashing the Commonwealth case against both parties. Surely. That was also from this morning's hearing. My nurse Cal screaming innocence versus consciousness of guilt. Despises his backwards way of thinking, an obvious fishing expedition. I put that up before. Thank you so much. Thank you, Kyle, for a bunch of super chats that I put up. You saw it blowing up. You said too optimistic. We don't know. The judge took it under advisement. We will see. Thanks, Kyle. Michelle, so it looks like he's framing it differently, but trying to go after the same thing using a backdoor tactic, now saying it's for consciousness of guilt rather than witness intimidation. He lied again. Yep. I think he made both arguments in his motion, but we'd have to go back and look at it. Annie Bev's pet interruptosaurus. Well done. From Canada. Appreciates me. I appreciate you. And she says she's rage quilting while watching. We also have a rage crochet club. Good morning, Vietnam, says Piney Woods. Thank you. D, does he even need Turtle Boy's records? Can he use Natalie's? I don't know that they have Natalie's records. Calling Turtle Boy is a terrible idea for the Commonwealth. Won't Natalie testify on this case for the Commonwealth? Is Natalie on the Commonwealth witness list? I don't remember. They're never going to call Turtle Boy. Thanks, D. I appreciate you. Lisa, he wants a buffer zone so as to not intimidate the jury, but wants the McAlberts to be able to come to closings. Yep. You did hear that right. Michelle, thanks for your Australian super chat. She said, tonight my house flooded. SES had to come. I rang into work. I know why, to see Karen Reed and team walk into Turtle Boy and Bradle Court and sit together. Yeah, it was worth it. Tarantino moment. It was. If you guys weren't here for that earlier, go back and rewind it and watch it later. Motions in CPA points out the obvious. No offense, but Karen Reed is just another case to ARCA. They have zero interest in messing with their reputation over her. You have an unbiased opinion, sir. Sit down. You're right. Churistity says it's insulting. When he says it as a statement, it alone is just true, but clearly he's implying all of those things he's saying. Thank you for your super chat. Lisa, pictures of the Stop and Shop paper bag, bloody solo cups, and the SUV parked right there. It was Canton PD's versions of industrial, light, and magic staging an unbelievable crime because it never happened in reality. Thank you, Lisa Davey, for your very kind super chat. Edward says he just wants another chance to depose the ARCA guys on the stuff that Lally didn't do. You are so right. You are so right. And she has ordered them to come back for another voir dire next week. She doesn't even say what the parameters are going to be. We don't know the date yet, but it's going to be next week. And that is a free shot at another deposition because Brennan wasn't there the first time. So he wants to, remember how long his voir dire on Dr. Russell was? It was like 2 days. Good Norfolk County citizen is here. Reminder, there were 2 other sets of human DNA. Yes, there were. They were never tested. Those were with regard to the stains on John O'Keefe's clothing, right? Thank you for the good reminder. Nathaniel Brown, thanks for gifting 5 memberships. Appreciate you. Why isn't the defense trying to remove her from this case, says Kim. They haven't made another motion to accuse. Maybe too late. They did it the first trial. She denied it. Kevin says, do you think Bev's blatant bias will be grounds for appeal if Karen is somehow convicted? I think bias would not be like proper grounds, but improper rulings and other things could be appellate issues. There's a lot of them that are already out there that could potentially be used, but let's think positively because there will never be a conviction in this case, in my opinion, Kevin, but I think you're right. But it just wouldn't be, there would have to be other reasons, not just saying she's biased. You know what I'm saying? Michael, why ask the defense outside of court when I can just engage in rank speculation in court? Exactly. Mention it all. Bethany Frankel says D1111. Thank you. Do all judges get to make up the rules on the bench? And I highlighted this, first of all, thanks to the 20, but also because you've already changed your username to, it's supposedly, not supposedly, Hanky. Thank you. I think that was rhetorical. So thank you so much. Piney Woods, this judge is outrageous. As an officer of the court, I object. I just said duck you out loud at her, and I haven't used that word and phrase for quite some time. It's insane. Thank you. Thank you, Boiled Frog, for appreciating me. Even when I'm under the weather, it's a difficult watch. Thank you for watching. I turned over a lot less. We were duped. Thanks for the 10, says this biased anti-bevy is really making me mad. We need to help Karen with her defense fund, as many have. Yes. I have a feeling she's going to need more help from us. Free Karen Reed to get justice for John O'Keefe. Thank you. Lower than Kangaroo Court is a Canoni court, says KC. Thanks for the super chat. Stifler's mom has got it going on, says so say we all. Thank you. Well done. Will you please put the link to Karen's defense fund in the chat? I will do that as soon as we start replaying the hearing. Thank you so much for reminding me. Do you suspect the murder charge will be dropped and the Commonwealth is trying for guilt on lower included to set up the civil suit the O'Keefe family filed? I think if they do drop the murder charge, I don't think it has anything to do with helping the O'Keefes in their civil suit. I don't know that it will be dropped, but if they're going to not bring in the Aruba sisters, they're not going to have a lot of motive, right? Even though they don't have to show motive. I mean, if they want to show murder, they thought that that Aruba stuff was helping them in the beginning. So I have mixed feelings on that. All right, we're going back. Thank you, Danielle. Did someone say Stiffle? And this was funny too. Brennan's little Stiffle has changed his or her name. And Kevin says, can we start calling Brennan Stifler? I'll allow it. I'll allow it. And this was very funny. Let's see how much you got. Says Freudian flip. He said one thing and meant a mother. Well done. Stifler. Stifler's mom. We get you. Josh says, shouldn't he have cited the authority for allowing the impoundment of sidebars in his motion? Of course he should have. But he doesn't seem to think that he needs to play by the rules. He just gets whatever he wants, or he asks for it and mommy just gives it to him. And that's the way it was with Lally. So he probably knows that from today or from watching the first trial, if he ever did. Thanks, Kay Willis, for gifting 5 memberships. I appreciate you so much. Anybody looking to leave the South Boston area, Kay Willis is a realtor. She will sell your house for you. Thank you. Let's get back because the break is over. And this way we can keep moving. And here we go. We're going to get to watch Alessi, so this is going to be fun. Their sound isn't up. It's not us. Why is their sound not up?
Before we begin, realizing how much everybody has to do before this trial, I won't have the voir dire of the ARCA witnesses next week. We'll have it before they testify. We'll do it the day before they testify. And we'll give you until then to comply with all Rule 14 discovery and see where we stand.
How can they
we don't-
prepare? How can they prepare their case not knowing whether ARCA is going to be allowed? Well, she's already said that they are allowed to testify. So we know that they're allowed to testify. But I guess the issue is whether or not the jury will be told that they were hired by the U.S. Attorney's Office. So she's not going to do the voir dire of them next week. And it's just like fly by the seat of your pants. How are they expected to try a case, Your Honor? Good ARCA can bring their lawyer. Well, they don't need a lawyer. The question is really whether or not the jury's going to get to hear that ARCA was hired by the U.S. Attorney's Office. That is a dumb idea. Let's see if they have anything to say. If you're ahead, please no spoilers. I would appreciate that so much. Thank you.
Don't need to bring them here next week unless you made arrangements.
No, I didn't make arrangements. I just want to make sure that we're very well defined on what issue is before the court that would justify a voir dire. I just want to make sure I don't think that's been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire?
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay?
So it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does that work for the Commonwealth?
No, I thought it was about
My
whether or not the
concern is if
FBI.
we have questioning of the witnesses the day before their testimony. And part of that includes the production of records, and they don't have the records with them. They're going to be unable to produce them because they would have to return home. And so having.
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah,
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
My discovery motion extends beyond Rule 14, and the reason why is it includes the communications between the parties, which is necessary to understand. So it's not simply Rule 14. We have a court-ordered discovery motion that we filed that includes the request for this information to show bias, and I don't want that to be overlooked.
All right. So talk to Mr. Alessi in advance. All right. And I'd like you to be able to tell me before we start the trial where you stand with that. Okay?
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
And I'm pleased to speak with Mr. Brennan at Your Honor's direction.
All right. Thank you very much. All right. So now we'll go on to your motion, Mr. Alessi.
All right, well, before he starts, hold on, because a couple of people are saying in chat that Ted Daniel has posted that the defense attorneys are now on the Commonwealth's witness list. So hang on a second. Oh, really? Well, here we go. Do they even know this? Because he just posted this 20 minutes ago. Let's just pause from this for a second to pull this up. This just gets to be more and more unbelievable. More and more unbelievable every single day. See, that kind of breaking news I'll allow because we can pause this for a second to look at this. Ted Daniel, 21 minutes ago, says Special Prosecutor Hank Brennan has added Karen Reed's legal team as potential witnesses at her trial, according to an updated filing. So this was just filed this morning. He has added Alan Jackson, Elizabeth Little, and David Yannetti to his witness list, or as I called it, the witless list. XOXO, Michael Marcy, Hank Brennan, Adam Lally. How can he put them on the witness list? Is that even a thing? What is he doing? I don't know. I can't wait to see an explanation for this. How can they do? They want to disqualify them? They're mad that the judge did not pull their pro hoc vice status, except David Yannetti is local counsel. He's not pro hoc. How is he going to add them? Because of the documentary he can, someone says? I don't know. We're going to see if they address this today. Somebody says it was a while ago, and it's just dated today. And he just tweeted this. Oh, today's the night. No, today's the 20th. Maybe it just got scanned in today. Because they've been scanning everything late, but it's dated yesterday. Do they know? I don't know if they know, but we'll see if they address it today. All right, let's get back to the hearing. I mean, just when you thought it couldn't get any more insane, it gets more insane. Okay. This is the motion to exclude Commonwealth expert witness Judson Welcher.
May it please the court. In my presentation today, with regard to Dr. Welcher.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me.
Such a bitch.
Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
His style of argument, he's a very, very experienced attorney. He's one of the best. And he lays out his argument for the judge. Your Honor, first I'm going to tell you some background about the witness, then I'm going to go into my argument, and then I'm going to do this, just to give her a little roadmap of where he's going to go. She doesn't like that. So last time she's like, you don't have to tell me what you're going to say next. And here is the snark. I thought I was snarky. Are you going to tell me what you're going to tell me? Because I don't need to know what you're going to tell me. Okay? Wow. Listen to that again. She was laughing. She was. Like, this is something funny, Judge Cannoni? Is something funny, Judge Cannoni?
In my presentation today, with regard to Dr. Welcher.
Listen.
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
In my presentation today, Your Honor, I'm going to, just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation,
Okay.
what the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Daubert factors. And this, again, is a pattern of the Commonwealth, where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the apt Daubert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide 4 parts of Canavan. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf, and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS.
He's a little bit slow but methodical. Is it too fast for you guys if I put it on 1.25 just so we could catch up? You good with this? Okay. Love you all.
Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test, absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative. That's the ipsi dixit comes right and is used in case of Canavan. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140-slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about 2 things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Canavan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area, and the Daubert-Lanigan analysis is referred to as the hard science. So He also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the deceased. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, there is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused, and caused is italics in the opinion, her to suffer from MCS. This was an error. They went on, quote, because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping.
Okay, I just want to point out that if you're on replay and this is too fast for you, you can slow it down on your end by going to this little settings thing over here, and you can slow it down. I have them at 1 1/4 just so we can catch up.
Several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion. In the concurring opinion of Justice Greene, he added an important point. I quote, further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science. The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Canavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support, what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks, and that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, at trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera. Last sentence. Such discovery is essential to an effective cross-examination and therefore to a fair trial. And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is essential to an effective cross-examination and therefore to a fair trial.
Thank you, Amy.
And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of a slide presentation. And this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the deceased. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rintala. We basically cited it for the proposition of qualification, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rintala was, listen, this person was a paint engineer at his company and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rintala. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference. And it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher in his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation. Skipping. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. There is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experienced in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Giulianelli conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Dalbert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Giulianelli's methodology or experience. Instead, it appears that Giulianelli designed these experiments on his own without any guidance. Reading down below, quote, Giulianelli's experiments also did not appear to have been performed consistently with basic scientific principles. We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Giulianelli did not repeat or validate any of his 6 experiments is also significant. There is zero in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. He continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important, what biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula, because biomechanical engineers want to know what's the force being applied, and when you do that, then you can then say, okay, is this force capable of causing this result?
Newton's law has entered the chat, and now the judge is really confused. Brennan's head must be spinning.
And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this case, is where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only using, but he's trying to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying.
it's not in the record, he would not be able to testify to it, but if it was in the record, he can refer to it as part of his opinion.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So I understand completely the foundational evidence issue. I understand all of that. But the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And we provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2A Romanets 3 and 4. Romanet 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say no evidence? That's not for a biomechanical engineer.
Yep.
And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer. Then he goes on to 2C. Testimony of Jen McCabe.
Alessi is a licensed New York State pharmacist, Heather? I did not know that. That's fantastic. For everyone in the chat who's saying that they emailed me and, just so you know, I'm going to assume that you weren't here earlier in the stream, but we've already broken the news that Ted Daniel has tweeted that David Yannetti, Alan Jackson, and Elizabeth Little have been added to the Commonwealth's witness list. That broke this morning. And I appreciate your emails very, very, very much. We've already covered it and we'll cover it again as more information comes in, but I appreciate each and every one of you with all of my heart. Thank you.
That's his heading. Karen Reed stated to her, et cetera, et cetera. In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe, or frankly, anybody's testimony? It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1:1. 42622 Julie McCabe, 42622 state grand jury page, etc. Grand jury minutes. That's testimony. It's testimony of lay witnesses. Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a deceased? They don't exist.
They don't exist.
4, and that should be stricken and not allowed.
Allow me to interrupt your regularly scheduled program because I have not interrupted that much during Mr. Alessi's stellar and learned argument to point out Tiffany did send me the actual page from the revised witness list, which Ted Daniel cut off in his screenshot that we looked at. And there's a footnote underneath page 8 of the new Commonwealth witness list, apparently, where they list 89, 90, and 91, Alan Jackson, David Yannetti, and Elizabeth Little. The footnote says, the Commonwealth notices that it may be necessary to call defense counsels to authenticate the defendant's numerous public statements. They know that they can't force Karen to testify. So he's saying that they're going to call her attorneys to authenticate her public statements. Why don't you call the reporters who were interviewing her at the time, or the director who heard her say that on the documentary? You don't need to call her attorneys to authenticate her public statements. That's insane. Thank you, Kim. If you said that earlier, I didn't see it, but Tiffany gets the credit for emailing me about it. Thank you.
4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, et cetera, of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist. He's not a hydrogeologist. He's not a geologist. He has no basis to.
Alessi loves to mention pedologists. Pedologists are like soil experts who talk about how hard the ground is. They wanted their weatherman to come in and testify that the ground was frozen hard as a rock, and that is what caused the head injury to John O'Keefe. And now they're trying to squeak it in through Judson Welcher, the biomechanical engineer, but he's not a pedologist.
Testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert. He is also, once again, talking about testimony of individual witnesses. So he says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, et cetera, and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
Wouldn't be introducing evidence of frozen ground from Dr. Wells.
What? That's the same as causation.
Cause of death.
He would not be offering the cause of death. I think
Liar.
he's scared of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. Hard ground and the cause of death are not within his bailiwick.
All right, thank you.
Okay, you probably couldn't hear what he said because he doesn't know where the microphone is, but he said, I will not be letting him talk about the cause of death, but his report just includes everything. And so, it's just in there, but he will not be able to opine about cause and death. If it's in his report and you didn't say that in your papers, that he's not going to testify to that, why did Mr. Alessi have to waste his time with all of these arguments if you're not going to be asking Welcher to opine on them, even though he's opined on them in his report? That is however many pages and his 140 slide PowerPoint presentation. Okay, Stifler.
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best.
Here's the issue. The issue is that he's going to lie later on and say, I never said that. That's what the issue is, because he just does that all the time in open court, Stifler and Boss Baby. And then he says, oh, I never said that. That's not what I meant. That's not what I said. Nothing's in the papers. You can't be held to anything that's in writing or sworn to or in an affidavit because they've got 3 attorneys signing off on one affidavit. It's wild.
Best just to go through each one.
Sure.
Thank you. So 4A, he says and this is what he means by totality of the evidence. Cell phone data. Where's his qualifications to discuss cell phone data?
Right.
That's a data forensics. We had obviously many moments I'm sure your Honor may wish to not remember, but with regard to Mr. Green, et cetera, we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, forearm lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E, I'm sorry, Mr. Brennan.
I don't need to interrupt. The frozen ground, we're not going to bring in. The air temperature is important because it talks about the density of the strength of the taillight. And that's part of the conclusion. So there'll be evidence before he testifies about.
Oh, let me repeat to you what he's saying. He's saying, we're not going to bring in we're not going to let him talk about the frozen ground aspect of it, but he is going to talk about the air temperature because the air temperature is going to be important as to how the taillight could shatter. Okay.
The density of the strength of the taillight.
The air temperature is important because it talks about the density and strength of the taillight.
Part of the conclusion. So there'll be evidence before he testifies about the weather we expect. And he can rely on that to talk about how that.
He can rely on the weather information from another expert to talk about the conclusions about the strength of the taillight. Why is he interrupting? Yeah, take all the seats, Stifler.
Might affect the taillight. But frozen ground, we agree. That would not come in through Dr. Welch.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay.
E, hat line and fracture location consistent with fall and posterior head strike. Extraordinary. Even the medical examiner in this case wouldn't venture onto that. But that is clearly an example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue. Now with regard.
This is interesting, Tough, because we have not been privy to seeing Welcher's report because the reports have been impounded as exhibits to these motions. And so he's telling us what's in the report, and it's wild stuff. Any attorneys in the chat who have ever dealt with expert witnesses and what they're allowed to testify and not allowed to testify to, we still don't know what James Crosby is an expert in. And the judge just let him in. It wasn't a close call for her like it was for Dr. Russell, who was a close call and had 2 days of voir dire. Crosby's just waved in without a hearing. And we still don't know. We know that he's testified as an expert witness, maybe in some other cases, in some other courtrooms, but we don't know what subject. This is insanity, you guys. Just insanity. You are being gaslit. You're not crazy. They're trying to make you think you're crazy.
Regard to F. This is the wayward, undocumented experiment that Dr. Welcher conducted. F, Romanet 2 should be excluded. It says drop test conducted by me with a hybrid 3 falling backwards, measured heads, G's of approximately, et cetera, et cetera. That experiment I've covered in what the case law requires for him to show. There is zero support for this experiment. I went through in Ventola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Ventola, the paid person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area, but you've got to show all of these things, including where is this supported by the scientific method? What studies? Did you repeat this experiment to make sure that there wasn't an error rate of concern? Every single deficiency in Ventola is extant with Dr. Welcher. His experiment must be excluded if Ventola is to have any meaning in Massachusetts jurisprudence. G, Julie, Nagel, and Ford occupants.
Oh, this will be good.
What does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts, that's not allowed.
That is funny.
And as egregiously, H, people inside of 34 Fairview on evening of 128, early morning of 129. H, Romanet I, John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet he's proposing to testify and state that. What biomechanical engineering principle is being applied there? The answer is none.
Wow, that's wild. That is wild. Because remember, right, Wolf built a cannon. The difference between this expert that they're proposing and the crash daddies who were completely impartial and only had physical evidence. They didn't look at police reports, statements in police reports, statements of witnesses. They didn't need all of that stuff. Their mission, and they chose to accept it, was, did John O'Keefe's body get hit by Karen Reed's car? Are the injuries to John O'Keefe's body consistent with being hit by Karen Reed's car? And are the damages to Karen Reed's car consistent with hitting John O'Keefe's body? That was it. They weren't asked, because of course the trial hadn't happened yet, but they weren't given witness statements of people. Tell them the guy never went in the house. You know why? Because for what they are doing, as far as accident reconstruction goes, it does not matter. None of that matters. They don't need any of that information. And so for Brennan to be giving this expert witness, Judson Welcher, who's I guess a biomechanical engineer, and then he's in his report saying that his conclusions are based on Julie Nagel's brother and the people in the car saying they never saw anybody get out of the car. And all the people in the house testified he never came in the house. And so therefore, he must have been hit by the car. Is wild to me. That's wild to me. Come on, man, really? I mean, that's just laughable at this point. And I can't believe that see, the thing with Alessi is he's so professional and he's so angry that he can't laugh at this because this really personally offends him. Because he is such a professional and this is what he does. That's his forte, is experts. You got to hear that again. The guy never went in the house. He's rolling, right? We need Alessi pom-poms. Yeah, we do. This is wild.
He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts, that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128, early morning of 129. H, Romanet I, John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet he's proposing to testify and state that. What biomechanical engineering principle is being applied there? The answer is none. Except for Karen Reed, everyone at 30 and outside 34 indicated John O'Keefe did not enter 34 Fairview. Even more egregious than
that's in his report, the expert's report.
So with regard to Dr. Welcher, I have, again, genuinely tried
Excellent
to assist
comment.
the court.
Excellent comment. Hold on, if I can find it. Chat's moving quickly, and I even put it on slow mode. Carrie B. People lie. Science doesn't. Science doesn't care about any of that. Slow clap for Carrie B. Well done, girl. Well done. You said it better than I could. Or, I could have maybe said it eventually, but I didn't think of it.
With regard to blue penciling his report to make clear, based upon the case law, what is within his bounds and what is not within his bounds, based upon his own stated parameters. And with regard to the case law about not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury. And the Massachusetts courts state Such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly, and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know, is he really directly or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, the case law is clear as I have recited. With regard to this experiment, prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment. And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts with an extremely jaded eye, as Rintala talks about. Both eyes get even more jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to the defendant in these cases by allowing experts such as Dr. Welcher to stray into all of these areas. In conclusion, Dr. Welcher is not qualified to do anything more than what the ARCA witnesses did, which is talk about and calculate forces and then determine whether or not those forces are sufficient to, and based on physics, are sufficient. So, Your Honor, we would request that because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis for an opinion. You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation that is unintelligible on its own. You can't understand it, and the report merely references it. It doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted, but there are different demonstrations that we do.
Partially, he says we need to redact any witness testimony or opinions on witness testimony. What? Are you now midstream just changing your whole entire expert witness testimony? I don't believe a word he says.
That's the demonstration at Meadows Road, which clearly fixed that the cars didn't contact the taillight. We want to produce the drop test, similar to ARCA's test. We intend to offer that. But as far as the extraneous commentary, no, that's not intended. It's not proper, and we wouldn't try to.
Do you intend to use all 140 or however many?
No, we were comprehensive in the production to the defense so they could see the data points, how it was produced. And so we've included, you see many of the slides is the cameras showing the different data downloads. There's only a fraction of that we would show.
Sorry, no, I can't turn up the court mic, but you can use closed captions for him because he's just standing up. He's not going to the podium.
Show is the drop test, the demonstration of the Lexus hitting Mr. Welcher's arm. And also we would want to show the ways locations based on the data that will be introduced through other witnesses and after it's been attested to and its reliability.
Okay.
If I may be heard on this?
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled to know.
Right. So this will have to be provided to you prior to it's done.
Thank you. And do we have a date so we can adequately prepare for trial, Your Honor, in cross-examination?
When will you have the redacted slides?
I can have them by Monday.
Okay.
And Your Honor, if we have an issue still, can we submit something to the court? Don't need another court hearing, but if Your Honor would like it, we're happy to do it just to get the basics.
Sure. So you'll get what you're entitled to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher is, in my experience, unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. These experiments, especially of the insufficiency of Dr. Welcher, cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court, as the gatekeeper, a basis to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard. That's the standard of the SJC. So we respectfully request that Dr. Welcher's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly what this witness is going to be allowed to testify to. And we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are. But I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Okay. Mr. Brennan.
No, let's wait until, can't wait to hear this. He doesn't even know what his witness is going to testify to because he doesn't understand the science or the
I'm
physics.
particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush.
Okay,
I'm not gonna
well,
address
I
that.
mean, silver linings, he did learn how to pronounce Alessi since the last time he got up and has been calling him Alisi. But of course, the first thing that he has to say is, I'm particularly disappointed. Well, why should today be any different than any other day, Mr. Brennan? I'm particularly disappointed that they called trial by ambush when they've been tattletale, nanny, poo-poo. They've been doing this to me for forever. Trial by ambush Brennan, that's his new nickname, in addition to Stifler. I'll let him begin again.
I'm particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has, but a case study in that is the ARCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery. ARCA and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire file to the defense with all of the raw material, all of
Don't dislocate your shoulder by patting yourself on the back.
studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCA even considered in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher cannot come in and talk about the opinions or testimony of witnesses as it relates to their statement. So for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagle and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report.
It sounds like they just fixed their volume. I don't know, you guys. I have my volume down to 30%. There's nothing more that I can do. There's a lot of complaints, and I just put them in the complaint box, and I'll take them under advisement. Is all I can say. My volume is at 30%. Please turn the volume up on your end. I don't know. We're not here to talk about the ARCA witnesses. You had your chance on that before. The motion you're arguing right now is about Judson Welcher. Okay, Welcher is what you're supposed to be talking about, not the ARCA witnesses. Okay.
You have one witness who decided to build a potato cannon for no reason that we know of.
Potato
no
cannon.
evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand. That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon. That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs, quite unlike ARCA, where it is just simply a conclusion.
Ad hominem attacks. That's what he's doing. He's got to attack every other witness because he's got no leg to stand on for the Welcher argument. See what he's doing? It's like, oh, look, there's something over here. Oh, look, something shiny. Potato cannon, look what ARCA did. Tell them the guy never went in the house.
And so when you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Lisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing.
Back to
Except that they don't
Alisi.
show it. They don't actually demonstrate it.
Back to Alisi. Look what they did. Nanny, nanny, poo poo. Back to Alisi. He couldn't remember. It's Alessi from 5 minutes before. There's Meredith in the back row. She looks like she wants to vomit, just like we all do. I think her face speaks for all of us. Wow. Look what ARCA didn't do. Look what ARCA didn't do. He's like the tattletale that you hated in elementary school. Teacher, teacher.
Fact, one of the complaints by Attorney Lisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on a study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made.
A study of the
particular, the
testimony
defense-
of certain witnesses whose credibility is at issue. Okay.
Takes issue with basically everything he's done. And just as a general perspective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Lisi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they give it. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from.
Oh,
the waterfall to
really?
the flagpole.
The text stream data now shows time and place? Well, that's new information. Because remember, the text stream data or the key cycle data that they used during the last trial had no metadata, it had no time and no place. And now he's claiming that the text stream data has time and place. So is he going to say that the 60 feet in reverse at 24.2 miles per hour was exactly at 12:31 a.m. in front of 34 Fairview? Is that what he wants the media to pick up? I'm going to take that back so we can see if he's lying, because I'm sure Alessi's going to get up and harp on this, because we do know that they went to Texas or something, right? To download the text stream data. Was Welcher there? I have questions. Hold on. He actually downloaded the text stream data because all of a sudden there's new software now. All right, I'm very interested in this. Hold on. He did lose my attention for a minute, but I perked right back up.
Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it didn't stop along the way. We know based on the phone data.
Wait a second.
Mr. O'Keefe's phone.
The Waze data is off. We already know that because of the clock that they use for Waze. Are you talking about the text stream data or the Waze data? Hold on. This is super important.
Text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it didn't stop along the way. We know based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes.
Look at Aidan's face. It's like my face. Like what? And if he's misrepresenting again, he better get spanked. They know exactly what time now she was in front of the flagpole. How come nobody saw the body? I have to take this back a little bit. Sorry for the delay, but I'm doing it. Aidan perked up too.
Which will be introduced through other witnesses at trial before he testifies. and it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his
Wait,
study.
so now the Apple Health data is accurate? What about him going up and down 3 flights of stairs? You can't have it both ways. You can't say the Apple Health data is unreliable and you could have been waving around your hand in the car and it would show you going up and down stairs. But now you're saying that the Apple Health data is going to put him in front of the flagpole at the same time as her car because of this new tech stream data that is now going to show the time and location of where Karen's vehicle was at that time? Huh.
Study. This is what he does. The
Yeah, battery temperature.
demonstration at Meadowbrook, John O'Keefe's house,
Meadowbrook.
is depicted by measurements, which is
I know you weren't here for the first round, but it's Meadows. It's one Meadows. It's not Meadowbrook.
been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging and the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows with great continuity the height, location of that broken taillight, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered as evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Melisa eloquently said, you need time to prepare. We know he's a very prepared attorney.
Melisa.
We'd like to prepare as well. And if we wait to get records and information to know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider.
Dude, let me explain something to you. Because again, you weren't here for the first trial. You had the opportunity to call all of them before the first trial. They were fair game for anybody who wanted to hire them or speak to them. You or Lally chose not to. And so they don't have to, you can call him up, give him a call. They don't have to turn over a witness that they don't intend to call. They don't need to pay 3 witnesses to come in when 2 of them can do the job from ARCA. He's insane. He's really insane.
We have that questioning well before the testimony, but we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery. Okay.
Yeah, please be heard. Please be heard. Lord, hear our prayer.
Like with Dr. Welcher's report,
She didn't let the third
what
one in?
Attorney Brennan did not say is even more important than what he did say moments ago.
Good. Let's hear it.
He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan.
Yes, please do. And also, it's like Beetlejuice, Beetlejuice, Beetlejuice. It's science and data. It's science and data. Beetlejuice.
Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology. There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the ARCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it.
Good. Call him out on his lies.
On a key issue that is disputed. Attorney Brennan also falsely stated that ARCA did exactly what Dr. Welcher did with regard to medicine and medical issues. That is completely false. ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You can then take the acceleration theory, even assuming the theory of the Commonwealth, which we contest, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration, and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The ARCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does, referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Dalbert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted, either in court opinions, which the court could take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Dalbert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries.
The New York just came out. He said called. That's what he called. I love it. Love it. I love this man. I love this man. I love his daughter too. I don't think she's there today. Somebody else said his daughter was there. I didn't see her today.
I understand what Dr. Welcher did. The question is not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Dalbert factors. So in conclusion, Your Honor, I go back to Rintala. I go back to Meeks. I go back to Case of Caravan. The Commonwealth has not today, not before, this is their fourth time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position, this equivalency between ARCA I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden. They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay.
Yeah, she's facing life in
Go
prison.
ahead, I'll hear a quick response.
He doesn't have a response because he's a dork and not smart.
Regrettably, I know Attorney Alisi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements.
I just want to point out that The Fray was capitalized as in the band The Fray, who I absolutely love. And so the closed caption person is having a little fun with this. Mr. Alisi has decided to join the fray. In what? In disparaging him? Okay. Find the mic, Beetlejuice. May the force be with us all.
He has decided to join the fray of disparagement. Now, he has
Disparagement.
said 3 times that I've made false statements. This isn't the first time that Mr. Alessi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not to mention it, because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alisi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one. It's purposeful.
That's all he's been doing the entire
and that is
time.
all part of the strategy here. Now, if you look at page 13 and 14 of Dr. Welch's report, perhaps that was missed in the review, there are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's all there.
All right, thank you. So we're going to move on to try and get some motions in quickly. The motion regarding the chalks, is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations in chalks prior to using?
No objection.
Okay, thank you. 583. Is there an objection to the Commonwealth's motion in limine to allow the expert Celebrite demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay. Is this something that can be done quickly, or is this something we need more time on?
15 to 20 minutes, Your Honor.
All right, so we're going to have to table this. We may end up coming back tomorrow.
What?
I can do it unless you tell me what
No,
Your Honor.
let's see what we can get before the luncheon break. The paper number 585, it's the Commonwealth's number 11. Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins, types of cases. So is there an objection from the defense on that? If there is, I'll hear
Yes, of
quickly
course
from the
there is.
Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
They want the niece and nephew's statements coming in to say that John wanted, and other people's to say that John wanted to break up with her.
Evidence of Mr. O'Keefe's state of mind is particularly relevant in this case. In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with the defendant. We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing. The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And it is clear based on that and other testimony that he was in the course of attempting to end the relationship with Miss Reed. And so his statements, especially over the course of the day of this incident.
All right, so what's the time frame? It's so over the course of the day, I realize that the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate
As
this?
far as his messages, I will
Or
look.
the statements or the evidence that you're trying to put in under this doctrine?
His niece would testify, as she did in the last trial, about the tumult in the relationship.
Okay.
And we'd introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
Okay.
And there would be nothing different from the last trial, other than the fact that we are not going to pursue the Aruba information. So it has actually a narrower time window than before.
Okay. All right, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended or anticipated. I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements. In some cases, they are multiple hearsay statements, or potentially multiple hearsay statements. John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range. But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Miss Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
That's
with.
what we were talking about, the bins, calls, those points.
Correct.
That need to be made.
And that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had what was considered and what was testified to in the first trial is a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. Couch it in whatever terms he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if he did, even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence, that was imparted, or those specific conversations were imparted to Miss Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Miss Reed at both C.F. McCarthy that night, as well as at the waterfall that night, show the two of them getting along, completely inconsistent with two people who were talking about breaking up. John O'Keefe wanting to dump her, and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or in the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job, had her own house. She was not dependent upon John for anything, not for money, not for room and board, nothing. They were, at the end of the day, just dating. The fact that she had some text messages with other individuals and other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these individuals were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one.
Preach.
And that's what the Commonwealth would have to prove to make this admissible. There's no suggestion in the facts that Karen Reed would kill John O'Keefe rather than simply break up with him or allow him to break up with her, and they both go on their own way. It's absurd. And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes exactly the opposite. They were a loving couple out one evening, having drinks with friends, in a good mood, and happy with one another. We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, a murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly, the court's words, not mine, and most importantly, would be likely to respond to it. The best evidence that the second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Ms. Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it, and act on it in a violent way that would take someone's life. But at the same time, they're stuck with the very clear fact that if in fact that's true, and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her. It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt. We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes.
Transcript of what? Oh, 2020. Oh, now he's gonna quote from the 2020 transcript, the television show 2020. Okay, here we go.
Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes. She was asked by Ms. Voss on June 20th, 2023 about that night, or the day before. She says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep. Now, in addition to her anger, she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. This is minutes before we allege the collision happened.
Yeah, Bella's mom.
And so in the interviews that she.
I love how all this stuff that was impounded, like these off the record notes that they were allowed to get from Voss, maybe not the off the record stuff, but the stuff that was redacted. Who's playing to the media now? Spec, who's playing to the media now? You. Because this is the only thing the media is going to report on tonight, right? Is the salacious stuff, not his outright lies and misrepresentations. They're going to point out that on 2020, Karen said she was angry with John that night, that in the notes of Gretchen Voss, she said she was temporarily frustrated that night, and that in some other documentary or something that she was pissed until she fell asleep, and that Jennifer McCabe had to mention Bella's mom in her directions to 34 Fairview because that was one of the women that he either had a relationship or slept with in the past. Poor Bella's mom got dragged into this. And now this is, as you can see, their new motive. They've steered away from Aruba. She was pissed because he wasn't calling her back. Glare and I did a show where we did a dramatic reading of all of their text messages from the day. And then we all put in our 2 cents as to what, we saw in their relationship. And she was somebody who wanted to solve this argument that they had that morning about her buying the niece Dunkin' Donuts iced coffee. And he got mad about it. And she wanted to talk to him, and he kept blowing her off all day long. He's an avoider. She's the kind of person who likes to solve problems. And she got pissed at him when he didn't come out of the house and call her back, and he was ignoring her. And she ramped up and ramped up and ramped up. She called him a pervert at one point because she did say in the documentary, and I think it was last night or maybe the night before, the one that's on Discovery ID or Max, she said there were a lot of women in that neighborhood that John had slept with or had relationships with. And so when he didn't answer me, I got pissed. Every man knows that, right? How many voicemails do you wish that you could take back? But he's going to twist it into something that the media is going to grab hold of today, and it's going to be great. Not.
Is provided to these different outlets. She discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision. And so we have,
according to Jen
statements
McCabe,
from the defendant herself that show the discord in the relationship, the anger, being pissed, the motive. Without reading them, because it's unnecessary, there is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
If I could just correct the record very quickly. If anything Mr. Brennan just said was true, he might have an argument. My goodness. It's important to get some of the facts right.
If anything Mr. Brennan said was just true, he might have an argument. Oh, I love this. They're not playing anymore. They're not playing. They've shown a lot of class and a lot of restraint, the defense team, throughout this entire debacle, sham, railroading of a kangaroo court. And they're not having any of it anymore. She's already said she's not pulling his pro vice status. So let it rip, my brother. Let it rip. Listen, if anything Mr. Brennan just said was true, he might actually have an argument. Here we go. I'm here for it. I may even slow it down to real time. I think we're still on 125 because I don't know if she's breaking for lunch. I don't know if she's breaking for the day. I don't know what she's doing, but I need to hear this in all its glory at regular speed. Here we go. Turtle Boy's face. Check it out.
If I could just correct the record very quickly. If anything Mr. Brennan just said was true, he might have an argument. My goodness. It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning, not minutes before the collision. He's read the every time he stands up, he says, "I've read the I wasn't there. I've read the transcript." We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
I'm sorry, I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done. This was during the time after 5:07, after the SUV leaves, we see One Meadows, and Jen McCabe and Kerry Roberts get together. And as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being about some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues.
And Karen just called him over and whispered something to him because nobody knows this case better than Karen. Her life is on the line, right? She's facing life in prison.
Concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning, dealing with, did you feed the kids donuts? And yeah, I did. You know, I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment, getting along fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Okay.
Before accusing somebody of getting it wrong, the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22. Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1, totally contrary to what you just heard. Totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband. Not my words.
All right, so we're going to break. We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this. Hold on, both sides, both sides. I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2.
Your Honor, if I could say one more thing.
Mm-hmm. Get the last word.
As the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it.
I'm not even thinking about it for the next hour. I need to go eat my lunch. No, you can't add one more thing. All right, I'm putting my volume back to normal, so you may need to adjust your volume. I've had a lot of volume adjusting this morning, so you may need to go back to wherever you were before, because this will be my volume until we come back for the after 2 o'clock. And right now, the time is 1:30, so we have a half an hour. Let's go to some questions, and then we're going to take a little break so everyone can run and get a drink or a snack or some popcorn or whatever it is that you would like to have in front of you for the rest of this afternoon, because this is wild. This is wild. And apparently the defense attorneys have been added to the Commonwealth's witness list. So we don't know what that's about. But there is a footnote there. So let's talk about it. Hold on. Jessica said, I'm loving you, Nettie. Today's feisty. I'm loving it. My Nan is excited for Alessia, and we love you, Melanie. Love from the UK. Hey, shout out to your Nan, Jessica. Danielle said, are Brennan and Bev allowed to have any discussions about the case without the defense present? No, they are not. Nope, they are not. That's called ex parte communications. They are not allowed in any jurisdiction. She says, seems like they might do that. Lady Tammy Eliza Little said they only gave the defendant's witness list to the Commonwealth. That means the Commonwealth broke the gag order and leaked it to the media. Well, I saw the defendant's witness list, and it was actually docketed by the court. So I'm not sure, but I think some form of that did break last week. And when people send it to me, I would not publish it because it was a Word document. I'm like, yeah, no, it's not stamped by the court. It's not numbered. The witness list that I have is actually numbered that it was docketed. So you may be right. Lady Tammy, you may be right because it was somebody tweeted it. One of the reporters maybe tweeted it and it was a Word doc. It was just a list of witnesses. It wasn't official. Nicole says, I remember Brennan insulting the medical examiner's intelligence on Tuesday. Now it makes sense why he did that since she is on their witness list, but I think he's indicated at some point that he's not going to be calling the medical examiner. So I'm confused. We need clarity on that. Thank you, Nicole. Letteros by Betteros said, I meant to say Squirty Bello is on the defense list. I assumed the Emmy wouldn't be called by the Commonwealth because Hank insulted her and he's trying to use his neurosurgeon to opine on the manner of death. Sorry for the confusion. No, we're all confused. We're all confused. So thank you for your super chat. Blessed in Texas. So, of course, for those who don't know, in the last episode 5 of Max's Reed documentary, the one that aired last night, AJ or Reed actually commented on Judge Kearney. Probably not a good thing to televise. Right. I don't remember exactly what they said, but I do remember that he did say something about the judge. If anybody remembers, let me know what it was. But it was Alan Jackson, I think, who made a comment about the judge. I think they were in a car. And remember also that this documentary was filmed during the trial. And I don't think anybody thought there was going to be a mistrial. And so they thought it was just going to air after the trial was over. And the trial's not over. And then now Discovery ID and Max have chosen to air it right before the second trial, which is not great timing for the defense. Casey says, when Bev is blatantly rude to Karen Reed's lawyers, it just makes the public love and stand behind them even more. Yeah, you know what? I think you're right. I think you're right. Let me pivot to a different feed for 2 o'clock. So I'm going to have to see whose audio might be better. Maybe Long Crime is better. We were watching, I think, Boston 10. We'll see. Thank you, Casey. I think that's a great observation. Mr. Alessi's daughter is not there today. I did not see her in the courtroom, but I could be wrong. She may be in the back row and we can't see her. She is not an attorney. Somebody asked, is she an attorney? She is not, but she was here watching one day and she was in the chat. And I said, can you email me? I would love to talk to you. And so we've been speaking. She's not an attorney, but she's a lovely, lovely young woman. Raksha said, I hope the defense doesn't believe anything that Hank says he's not bringing into the trial because he's a liar. Yeah. He has said a lot of things that have been shown to be untrue. And so there he just tried to make it seem like Alan Jackson was lying. But again, I do remember some testimony I've watched so much stuff on this trial, as you know, we all have. I do remember her saying that Jen McCabe did say in the directions, she did mention Bella's mom and that did make her mad. So I do remember that now. Piney Woods Long Crime. I would love to give memberships. I don't get that option on your page. I don't know how. I don't know. Maybe somebody can help you. It might depend on whether you have an iPhone. Well, let's see. I have an iPhone. There's a little $sign at the bottom. I don't know. I appreciate you, but I technologically, I'm not that wicked smart. What the duck? Thank you for giving me 5 memberships. And for those of you who were gifted randomly, thank you. Random thoughts. Brennan equals Marvin the Martian. Thank you. Hi, I'm Al Roker, and the ground was hard, yo. So say we all. Thank you so very much for your super chat. Can we please refer to her as Aunt Lydia? Motion granted. Motion granted. Because, you know, the other side thinks it's so rude and disrespectful. We call her Auntie Bev, and I haven't been calling her that. I've been calling her Judge Kearney, but Aunt Lydia from The Handmaid's Tale, if you know, you know. Thank you for your super chat. Please correct me if I'm wrong. How can someone get charged with murder when the cause of death is not shared and proven at trial? Oxymoron, anyone? some of the case law in Massachusetts seems to go that way. Massachusetts is like the land of the lost when it comes to procedure, case law, and normal courtroom procedure. So it doesn't say homicide, and these charges never should have been brought as a murder anyway. And we're all in the upside down, inside out world of Narnia together. Thanks for your super chat, Magnolia Gypsy. Brennan just wants this guy to talk about it all. Welcher is a catch-all expert. Yep. Thank you. Carrie Bishop Henk could learn a lot from Alessi. Maybe he could even learn how to pronounce Alessi. Wouldn't that be nice? Colin Alessi is here. Polycarbonate does not become brittle until its temperature is negative 40 degrees. Thank you. Thank you, David Reese, for schooling us. Chloe Albert's Revenge says, I call him Oscar Pistorius. He hasn't got a leg to stand on. Too soon? Thank you. Nina says, this trial will be far worse than the first one. Hank has no limits, and that's scary. They'll do everything to convict her. I think a lot of people agree. Audrey reminds us that the judge refused Klein, the third expert from ARCA, because he wasn't a PhD. I forgot that. I would have to go back and watch. Thank you, Audrey. When did she connect to the Wi-Fi at One Meadows? I believe it was 12:36 a.m. Chat, you can correct me if I'm wrong. I think it was around 12:36. It says pin it on Proctor. Sandy B, love how he warned her about her prior decisions were an error on Wolf. Lying Brennan, where's the grave concern? There's no grave concern. There's no grave concern about anything the Commonwealth does. They just have free reign. Do you see how the Commonwealth, their bench is attached to the judge's bench as if they are one? Their table, rather, is attached to the judge's bench. It's as if they are one. The Commonwealth and the judge are one. And then the defense sits behind them. Courtrooms that I've been in, the benches are side by side. I mean, the tables are side by side and they face the judge together. This is really weird. It's a small courtroom. But again, in the big courtroom where the trial was supposed to be held, it was pointed out by the defense team that half of the jury would be looking at the back of the witnesses' heads. The judge said, well, Mr. Jackson, that's the way we've been doing it for 100 years. And he said, well, just because that's the way you've been doing it doesn't make it right. So they moved to this smaller room. Piney Woods, Hank is still trying to bolster his expert who relies on contested testimony. Hank is going to introduce this expert and Bev will allow. I'm incensed. No justice. Thank you. Miners Kel says, why was John worried about Karen not with him all weekend for the storm? Yep. Why did John keep asking her to come over? Yep. Why respond to all texts within minutes? Right. He was like, oh, Karen, you're going to have to come here. You're going to have to come here. Remember, she had the plumber coming and he got mad. He's like, well, I hope your plumber's hot at least. Clara and I read the text. It was interesting. He really wanted her there. He needed a ride because Kurt Roberts, Carrie's husband, had to be home. He had to be home because he had to clear the driveway because otherwise Carrie would come home in a mood. We were all there. Nina said, one thing's weird. Karen repeatedly calls John O'Keefe a pervert on the voicemails. Why a pervert? I never called my partner a pervert. Any explanation? Yes, I do. Because that was explained, I think it was last night on the documentary. Karen said there were a lot of women in that neighborhood that he slept with. And so when he was ignoring me and not returning my calls and not coming home, I got angry. And I think that's why she said she called him a pervert, right? Anybody here who watched the documentary last night, the final hour? There you go. Thanks, Nina. That's what Nurse Kel says, duh, she was angry. He ignored her calls and texts. Yep. Pies Bev says, watching this trial, one would never know that Bev isn't part of the Commonwealth's team. Totally outraged. Thank you for your super chat. LJ, Hank always speaks in apophysis, which is a rhetorical device where a speaker or writer brings up a subject by denying it or denying that it should be brought up. Apophysis, did I pronounce that correctly? Thanks, LJ, for teaching us a new SAT word. Love it. Bias Bev, I'm scared for Karen Reed, not because the facts aren't on her, but because Bev is on the Commonwealth side. A lot of people feel that way. Tanny says, angry about what, though? Him not answering her calls or coming home? Yep, that's what she was angry about. LJ says, Hank speaks methodology. Hank speaking methodology, and then you said it again because you probably thought I didn't see your first super chat. But again, thanks for the extra 10. Apophysis is a sly debater's trick, a way of sneaking an issue into this discussion while maintaining plausible deniability. Thanks, LJ. And LJ says, Bev needs a smoke. Look at LJ coming in with like 3 super chats in a row. Thank you. Elle Woods is here and she says, sorry, Melamaz, I'm guilty of caps. Thank you all for all that you do. Go Jackson. Thank you, Elle Woods. Pro Gamer says, I hate to say it, but Jackson was wrong. The ex hookup mom was mentioned on the way to Fairview after Waterfall. You're right. I remember it too. Hate it when my team messes up. I know. This will be overly exploited. Well, Brennan got up there and tried to spank back, but listen, he said a lot of things that weren't true either. I think that's what Karen called him over to say. And I don't know if he picked up what she was laying down, maybe. But I know I've heard it before too. And I just can't remember where and which one of the many interviews she's done, which are going to come back to bite her, I believe, in my opinion. Double Trouble 247. Bev's hangry. She needs a white claw. Thank you. Kyle says, funny. Brennan often uses he wasn't there. Yep. Then he cherry picks a 4-year-old note. I believe Bev is risking her career here. Thanks, Kyle. Team Wicked Smart versus Pure Wicked. Thanks for the 5. So Septic Tank wants to put up more barriers and use force against Karen supporters, but they never, ever protected the crime scene. Unbelievable. Such a great point. Can Bev compel AJ, Liza, and Yannetti to testify as a witness? I don't know that there's any authority for that. He said in his footnote where he added the defense team to the witness list today, apparently. Well, it's dated March 19th, but I don't know if it was docketed or scanned today. He says the Commonwealth notices that it may be necessary to call defense counsels to authenticate the defendant's numerous public statements. No, it's not how that would be done. That would be done by calling the reporter who interviewed her. Right? So I don't think so, Sue, but I think it's a great question and open to further debate later. Mary Coppola, thanks for the 20. The defense needs a paralegal with a binder of transcripts of these motions to pull all the Brennan, I'm not using that, or I am using it during trial to call him out. I'll fly there and volunteer to do that. He's a snake. Oh, Mary, thank you so much for doing that. Mary's a paralegal and she's offering her services. Thanks, Mary. Max Bang says collision. A vehicle collision was never reported nor proven. Free Karen from this madness. You're right. You're right. There was never, ever a motor vehicle crash report ever even filed in this case. We know it. It's also interesting that she said initially, oh, well, we can come back tomorrow and argue that motion, Mr. Alessi, when she knows damn well not only is Alessi working for free, but he's from New York. Really? He can't go home and see his family? You're going to make him come back tomorrow? Then she did let them argue that motion on Judson Welcher. So there's that. I have pinned the Karen Reed Defense Fund in the chat, and I would kindly suggest to you that if you want a super chat, just super chat it right into the free Karen Reed Defense Fund. She needs it. And that would be really, really nice of you to do. Thank you, Scott, for the Venmo. Says you're amazing. No, Scott, you are. Oops. All right. So that is 614, which we have. Yeah. So it turns out that this witness list or witless list, as I say, was actually scanned today, March 20th, and was scanned into the computer around 8:44 a.m. And this is a new witless list with a couple of footnotes. So we may take a quick look at that, or we may just go on our break and then come back because I'm not feeling that great, as you can hear and tell. And so we may do that when we come back. So let's just. Team Wicked Smart versus Pure Wicked says, Telly Buchanan spent time and taxpayer money to fly to California to interview Natalie in person. It never went in the house. That's right. Natalie is the German friend of Karen's or former friend of Karen's. They went to college together, I think. And she reached out to Karen on Facebook and she was like a turncoat. Like she was a mole. Like she pretended to be friends with Karen. And then in the end, she turned on her. And it's wild. Thanks, Nancy, for your Venmo. Says, I love when you talk and explain things for us. Hope you all feel better. Thank you. Thank you. I'm going to go get me some hot tea. I'm going to go get me some hot tea. And I did say the Goodwins sent me some photos of them in the new merch, and they're just totes adorbs. I'm not going to show their pictures to you because, we're not going to dox anybody. But here's what we're going to do. All right, everybody run. Go get yourself a snack, a drink, whatever it is that you would like to imbibe in right now. It is 1:45. Court allegedly will be back in session in 15 minutes. We're going to take a 15-minute break. I'm going to put up the court is in on break sign. And see you around 15 minutes from now. Smash the like button if you are taking a break and coming back, because that really helps a girl out. All right, 15 minutes. We'll be back. Okay, we're back. All right, we'll try Core TV this time. We'll see if their volume is any better. And hope everybody had a chance to get a little snack. Look, the fan is back. Anybody miss the fan? Core TV has 1,500 people watching, and we've had over 10,000 people in here all day. So I don't know. Is mainstream media dead? I don't know. Maybe. I don't think they're happy about it. The fan is making me nauseous. Wendy Sue, can you review what a proffer is that was given to Higgins? We don't really know if a proffer was given to Higgins. It would have been like a deal with the feds. And is that still in effect for this trial? We don't, I've never had official confirmation that he was ever offered any sort of proffer in the federal investigation. That was a rumor that was around for a while, Wendy Sue. And so I don't know. Core TV chat is members only. That's why. Oh, but still people could be watching it and not participating in the chat, right? So I don't think there's ever been any confirmation of the Higgins proffer. It's like when they give you immunity and you offer a deal. You're offered a deal in exchange for immunity. I don't think there's never been any sort of confirmation of that. Thank you, Kindergarten Cop Scott, for also saying no outside drama in the chat, please. That includes family situations. Who is or isn't in court? Baked goods, except cupcakes. Thank you. We try and keep it clean in here. And we try and stay away from the drama and the hyperbole and the speculation and the rumor. And so thank you for the moderators, Kindergarten Cop, little cupcake. Team Brittany is here. She's amazing. I get the Snap message a lot. I used to get it until I cleaned out my cookies and tried to clean out some of the stuff on my computer. But I was getting the Snap for a lot during just using YouTube. Right? Oh, we love you too. I love you too. I love you guys too. Oh, looks like they're back. Thank you on Venmo to Dennis. Oh, turn up your volume, guys. Oh, wait, did I turn it up? No, I have my volume on.
Talking about voir dire, so I don't want to run out of time for that. So what I plan on doing is finishing these motions by 3 o'clock. We'll give each side 2 minutes. We'll see how we do with that. And we'll try and get through this. Juror questionnaires, have you provided those? Remember we talked about it the other day? Have the two of you worked out a...
Yeah, they're limited to a
questionnaire?
one-page
I know you
questionnaire.
asked us to, we have not.
Thanks, Pam.
We have not, we haven't.
All right, so today's the final trial conference where I'm supposed to have all of this, right? Can you do it before you finish? Well, let's see where we get with the motions and we'll see about that.
And Your Honor, if I could I finish that last point that I was about to make just before?
Please do.
30 seconds, Mr. Jackson.
30 seconds. I want the court to be super clear about this one point. What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. But on the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day is when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear. is
I
that
understand what your point is in making
there
it.
was no animus, no
So-
evidence of animus on the night in question.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure
all
that's
right.
clear. Thank you.
All right. Well, Mr. Jackson, you can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yannetti.
So you have 2 minutes, Mr. Yannetti. That's
2
sort of a
minutes?
yes or no, and then I'll hear the Commonwealth.
And I'm sorry, I did not hear the question. Yes.
All right. So I'll hear you on your motion, Mr. Brennan, and then a 2-minute response.
Well, you can't limit them to a 2-minute argument and a 2-minute response on one of the most hotly contested issues, evidentiary-wise, in this case, which is the third-party culprit defense. because you want to go home for Thirsty Thursday. That's insane.
Jimmy, keep track, please.
Jimmy, keep track. Set the
Go ahead.
timer,
Thank
Jimmy.
you.
Set the timer,
During
Jimmy.
the first trial, Your Honor made a ruling prior to defense presenting any evidence or questioning any witness about third-party culprit. The defense needed to provide sufficient evidence to pursue or place that issue in front of the jury. The defense, in my opinion, looking at the opening argument, ignored that directive by the court. The very first words of the opening were directed to third-party culprit. And thereafter, throughout the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown. We know from the defendant's statements that there was a position taken on the front of the courthouse steps that everybody knew who the third-party culprit was. That position changed in the Ted Daniels interview.
We all know
When they were
Steve.
asked about third-party culprit, Mr. Jackson, and the defendant said they did not know. And so despite the recent position that they did not know who the third-party culprit was, in our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there's this vacillating position on who the third-party culprit is and what evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point. And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of the Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
See,
I've read your motion. I've read your memo.
okay.
Or the pleadings.
Lyle
All right,
Lovett
Mr. Yannetti?
has entered the chat, and I have a cold, so this isn't going to sound so great. But anybody a Lyle Lovett fan in the chat? You know why they're only getting 2 minutes? Because she's already made up her mind. Bomb, bomb, bomb. She's already made up her mind. It's in the playlist. The playlist is linked down below. Turn it on real loud.
Jim, why don't you stand when it's done?
Jim, why don't you stand when it's time for them to be
Your
done?
Honor, I can't do this in 2 minutes.
Thank you.
Well, then we'll hold it. We'll
That's
hold
fine.
it to the end.
That's fine.
All right. Mr. Lessie, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear
No.
you for 2 minutes on that.
Kim Jong Kanone.
My 2 minutes start when I get to the podium.
Yes.
Thank you.
Take a minute to get there while you gather your thoughts. This is like, wow, wow.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully
This is Ian Whiffin's courtroom demonstration that he wants to do.
aware of what happened in trial one. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration, what it's going to be. They're looking, to me, this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, again, we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffin to use the highly disputed extraction reports to demonstrate Celebrate Software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary. It was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contained several camera angles of the property, and the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
All right. I appreciate your brevity too. Thank you.
You're welcome.
Mr. Brennan?
Thank you.
He's pissed. Alessi is pissed, and so am I.
The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see
It's a new trial.
the data in action so they can appreciate
It's a
the
new trial,
legitimacy
Mr. Brennan.
of how the data is stored and how those windows are opened. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can read along and see them.
Okay. Thank you very much. I'll get a decision quickly to you in that.
Yeah, of course. You'll decide that one quickly.
Does the defense intend to bring up any bad character or misconduct of John O'Keefe or any witness?
No, bad character evidence is inadmissible.
Right.
To the extent that evidence could be used for like motive, opportunity, all the alternative, under proposed rule 404, we reserve the right, but we would approach sidebar before introducing any such evidence, and certainly not against John O'Keefe.
What do you say, Mr. Brennan?
If we have advance notice, I think that's appropriate. I don't want to wait until we get the sidebar. If the defense has an intention of offering what would otherwise be prior bad act evidence, but they think it meets an exception under the rule, then they should propose that evidence if we have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do
Okay.
not believe we will be opening on that at all.
All right. So, okay. So what I'll do
Who's gonna do
is
the
not
opening
during the
now?
opening and only with advance notice and a ruling.
What would the advance notice be, Your Honor?
A week before trial, a week before the evidence starts.
Thank you.
Kyle, I'll allow it. You can add bourbon to your pain management routine. You deserve it today. No, you're not a sot. Thanks,
Okay,
Kyle.
that's paper 587, Mr. Clerk.
Thank you.
Mr. Clerk, Jim Clerk.
Commonwealth's motion for an offer of proof regarding calling District Attorney Morrissey and victim witness advocate Steve Nelson.
Oh yeah, let's.
And it also includes a request to exempt from sequestration.
Your Honor, with regard to this motion, we have on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yeah.
The issues do go strictly to trial strategy and attorney work product. So any such offer of proof, we would ask, we make that ex parte. I can tell the court, just to kind of streamline things, we would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly we could make those offers of proof at the appropriate time.
Okay.
Thank you.
All right. I'm satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would like the victim witness advocate to be able to.
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't worried about the sequestration aspect of it. I should have mentioned that.
Okay.
Thank you.
All right, so they're both exempt from sequestration.
Because the McCabe's and the Alberts need support in the courtroom.
Okay.
We don't know if they're going to be allowed in the
So
courtroom.
the other motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings unrelated to this case or unfounded allegations. Well, this is in a little bit different posture now than when the Commonwealth filed it.
Yeah, because Proctor got
back
fired.
on March 10th, right? With Michael
is.
Proctor being fired. Do you need some time to reconfigure this, or you want to just?
We
be
do need
heard?
pom-poms.
And for this, I'll give you both 3 or 4 minutes.
Oh, what
I
kind
think it'd be
of
helpful to have more
bloviating
time. I can
nonsense.
report that when we learned that
When you look up bloviation or bloviate in the dictionary, I think there's a picture of him. Let's see how he defends Proctor's firing. Is he going to say that Proctor's going to appeal and his appeal is going to be granted and he's going to be undishonorably discharged? He'll be recharged honorably. Yeah, we are in the upside down. We are.
I think it'd be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us,
Oh,
to
okay.
both of us. Now, I have not seen it.
Okay.
It may be voluminous. It's something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant for the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd object to. Traditionally, ultimate findings or opinions of a advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there and what should be admissible and what shouldn't.
All right, so you just received it. When do you anticipate being able to review it and forward at least what you feel the rules require you to forward? And then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to provide them?
They have a copy of everything that we got.
Oh, okay.
We had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their position is? Maybe they found him acting unbecoming of an officer. I don't know.
You don't know? We know because we looked at him yesterday with Mark Betterow. We know exactly what they were. Everything that he was fired for, except for the drunk driving incident with Kevin Albert, is related to this case. He was fired for his behavior in this exact case. Okay, is my sound again too loud? Is my sound again too loud? Because the sound on Court TV is much, much better now. Sure, I'll do it. Yes, it's too loud? Okay. All right, give me a second. Everyone else says my sound is perfect. I don't know if people are behind. I can't believe this is real life either. Now it's down. Yes, too loud. I like to hear. It's good. No, I can't even do you guys go into, I just out of curiosity, do you go into Emily Baker's stream and tell her to turn her volume up, turn her volume down, how to run it? Do you go into lawyer, or is it just me because I've done it before? So I'll do it again. I'm just wondering. I got almost 10,000 people in here. I'm not a cupcake. I can't please everybody. I just can't. Now I'm too low. Holy fuck, man.
Conclusions of what I'll probably object to. The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I would need, I think, till the end of next week.
Is that a same timetable you would have whoever's arguing it for the defense?
That's fine, Your Honor. I would just ask for notice about what specifically the Commonwealth is seeking to exclude. There were some, even just in the motion that they filed, there's inconsistencies.
Yeah, but I think it's all different now, right?
Exactly. But there's
So-
just inconsistencies between the title and then what's actually in the body of the motion. So as long as I have clarity, then I know what to address.
Okay. All right. Is this something we should come in the day before impanelment and deal with?
I'm happy to come in if the court's available.
Want to do that?
That's fine, Your Honor.
I'd rather not have anything, but I think it makes sense that we at least give you that time and then the weekend. And if you go through it, I'd like something by next Friday too. If there are materials that the two of you are disagreeing about, so that I can view it next weekend and then we can have a hearing the following Monday.
Yes, Your Honor.
Okay.
Does the court intend to have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear it.
That's fine, Your Honor.
Can you
I'll move
have,
as quickly as I can. I have a lot of
Okay.
obligations over the next week. I'll try to facilitate it. I just don't know.
all right, without knowing how much is in dispute, Ms. Little, you have no idea how long it will take you to address that, right? So.
Correct.
All right, so Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed, and when you, or that you feel should be excluded. And when you provide that to the Commonwealth, I'd like you to let me know as well.
I will.
All right, and then Ms. Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it and we can do it. So I guess we won't meet on the 31st on this?
Thank you, Your Honor. I appreciate that.
All right. So on the 1st, you'll tell me how much time you need. All right, so Mr. Brennan, since we are making good time, I'll let you go back and finish what you were saying when I gave you your 2-minute, when I cut you off after 2 minutes on third-party culprit. And then Ms. Giannetti, I'll give you both up to 5 minutes on this. 5 minutes is a long time, Ms. Giannetti. Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're
last time I said I
5
wasn't
minutes is a
excluded.
long time. 5 minutes is a long time. You know what else is a long time? Life in prison. That's a long time. Life in prison is a long time. 5 minutes is a long time for an argument on third-party culprit defense, which could be the difference between sending an innocent woman to prison for life. Really? How about a decision on the motion to dismiss? How about that?
Including it, you just couldn't open on it. Right? So that's where I'm at this point, and I'll hear the different sides. So,
if that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance,
She didn't
but
say what the ruling was.
you know, I guess I'll hear you on your motion.
So she's allowing third-party culprit, but they can't open on it? Did she just give her ruling? Because she hasn't said her ruling yet. So who knows what the hell she's talking about half the time. Right. Thanks, B. May.
The requirements of providing evidence to support third-party culprit are clear. The evidence has to be relevant, it can't be speculative, and it can't tend to prejudice or confuse the jury. If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged. And so what we would want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance between who they choose as a target and the crime itself. Looking at the transcripts, I do not see that they've met a substantial basis between any particular individual and John O'Keefe. If we start from the premise that every single witness who testified that John O'Keefe never entered the home at 34 Fairview. Every witness, there is no substantive evidence that John O'Keefe ever entered that home. So to open up an invitation for the defense to start to present evidence, sometimes alleged prior bad act evidence or character evidence, is unfair because then it becomes a mini trial for each witness. And so I haven't heard any basis or any proffer by the defense that would substantiate any particular witness is a third-party culprit. Now, there are some cases that saying you don't have to actually identify the witness. Those are particular circumstances where there is still substantial evidence that an unknown person had committed the crime. That is not the case here. They have used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we've never seen a proffer by them. Who is it that they're going to claim as a third-party culprit? What evidence do they have that they want to introduce? There has to be parameters and limitations if they're going to try to introduce third-party culprit evidence, not only about who the person is, but what evidence are they going to introduce? Otherwise, we're going to spend half the trial at Tsar by fighting whether this is substantial, whether it's supported.
He said farting.
So no
He said
profit has
farting.
been made.
Hold
I
on,
think that
I'm rewinding it. He said farting. Listen.
But what evidence are they going to introduce? Otherwise, we're going to spend half the trial at Tsar by fighting whether this is substantial, whether it's supported. And so no proffer has been made. I think there's an obligation to the defense to identify who the third-party culprit is and what do they want to introduce. Do they have a witness? Do they have evidence? Do they have any records? Simply assailing people's character randomly is improper. It's unfair. And then it causes the Commonwealth to have to spend extraordinary time rebutting, which is going to confuse this jury, and it's prejudicial. So I think that the court should order the defense to articulate who they claim their third-party culprit is and exactly what evidence they're going to introduce to support that claim. It's not until they articulate it we can really fashion an argument for the court, whether we think it is appropriate or whether we think it's insufficient. But now it's just an empty box where, as in the last trial, the defense can simply get up and blame anybody and everybody. And that's not the way the court in the course have seen third-party culprit evidence. There's a standard, there's an obligation. It hasn't been met. So at this point, the court should preclude third-party culprit evidence. They could certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer and a finding, there would be no guardrails, there'd be no parameters, and it would be chaos.
All right. So, Ms. Giannetti, I will hear from you, and I'd ask you to focus on, could you tell me whether this is pure third-party culprit, third party as it goes to Bowden, or is it simply somebody else did it and we don't know who?
This entire case is off the rails. There are no guardrails. There's been no guardrails. The whole side over here has thinned out. Aidan Kearney has left the courtroom, I think. A lot of media have left too. They've just lost interest because they know they're not going to report on anything except some salacious stuff they think they heard this morning. But there are no guardrails here. This whole thing is off the rails. This whole trial and persecution has already jumped off a cliff, like in Colorado, where there's no guardrails on the side of the road and you sort of like winding around, roads in the blizzard and you may slide off the cliff. Have anybody ever driven to like where Coachella is? Have you ever driven up that mountain road? Wow, that's where we are right now. That's where we are. Mhm.
The second alternative, in other words.
Okay, so that's a little bit different, Mr. Brennan, not pure third party. I'll still go ahead. You can go over there. It's a little bit different if it's third party as it goes to Bowden, but we know that it's not admissible if the police didn't know about that third party and not act on it. So are you going to tell us who last time you
Had they
told
done
me?
a fucking investigation, they might have known who the third party is. Yeah, I cursed. Sorry. Bleep. Headphones, earmuffs, whatever the hell they call them. If they had done an investigation, they might have figured out who the third party was and not acted on it because they didn't do an investigation. They didn't go in the house. You know who didn't go in the house? Them. Law enforcement didn't go in the house. That's who didn't go in the house. John O'Keefe went in the house. They might have known if they had done an investigation. Come on, man. That was a stupid thing to say. Have you paid attention at all? A Bowden defense, and it's Bowden in Massachusetts, is evidence. It's a defense that says it's different than third party culprit in that it says the police investigation was so shoddy. The police investigation was so shoddy that there's no way in hell that you could ever find my client guilty. There's no way in hell you could ever find the defendant guilty because the police investigation was so crappy. That's a Bowden defense. And she's saying it's a little different if it goes to third party because, if the police didn't know who the third party culprit was, it's not admissible. Where are we? Oh, that's right. We're in Massachusetts. I forgot. No shade. I love my Massachusetts viewers so much. And your accent. Listen to what she has to say about this.
It's a little bit different if it's third party as it goes to Bowden, but we know that it's not admissible if the police didn't know about that third party and not act on it. So are you going to tell us who? Last time you told me you don't have to prove that, but can
Well,
you
it's
make an
still our
offer?
position that we don't have to prove or narrow it to one potential third-party culprit.
Are you saying it's several?
3, yes.
Okay, so can you tell me the 3 that you say it is?
Sure. So the potential third-party.
That's like a cliffhanger. They can use CJ, the great question. They can use Bowden and third party defense. They can use both. And they did that also in the last trial.
Culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert. I have, evidence with regard to each. I'm sensitive to the fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
Well, I'm just sensitive to the fact that the court is seeking not to, pollute the potential.
So we can do this over here.
No.
It's up to Your Honor.
He wants it to be an open
Why don't I
court.
see you preliminarily over here?
For the God, really? Let's hide even more of the shenanigans, tomfoolery, and ballyhoo from the public in this case than you've already been withholding. Let him talk about it in open court. Brian Higgins, Brian Albert, Colin Albert. It's Robert Cosgrove, it's Colin Albert. But no, she's not going to let him say it in open court because, everything is very secret here. Everything is very secret in the bowels of the Norfolk Superior Courtroom where there is no justice. There's no justice. Shenanigans, tomfoolery, Ipsy-Dixit, and ballyhoo. They're at sidebar right now. And they even want to keep these secret. Anybody who wants to go get an FTR account, I think it's free. Go get one. Because you too can order transcripts of the sidebars if she chooses not to impound them or seal them. Yeah, we got to protect the witnesses, not the defendant. Right. She's only facing life in prison, but you know what? No big whoop. No biggie. It's cool. Let's just, keep on keeping on with the bullshit. Keep on keeping on. Thanks, Beva. Bias beratements. Thank you. I don't know. Maybe people are just trying to piss me off and trying to get me to rant so that they can clip it and put it on Twitter. Maybe that's what it is. I don't know. Nick Starro is here. He says, this case is a perfect example of my you can't un-F a cluster F mug. And look at that. He knows I like the clean language, even though I just let it rip. Nick Starro is also a YouTuber. He's amazing. Check out his channel. Thanks, Nick. Kim McMillan, if they get in the harassment, can the ARCA guys talk about the harassment that they've received due to Spanky? That's a great point. They, too, have been harassed by the crazies on Twitter, the Twidiots. Dr. Wolf's family was doxxed. Wife's picture was put out there, kids' pictures put out there in an attempt to intimidate him from testifying at trial. You want to talk about witness intimidation? That is good old-fashioned witness intimidation. Are those people going to be prosecuted? Nah, no big whoop, no biggie. The only thing we're going to prosecute is if somebody like Aidan Kearney walks up to the window of D&E Pizza and intimidates the window, stares into the camera for 25 seconds. We're going to put a felony charge on him for that. Anne says, I think she's just lost her attention span for the intellect of the defense lawyers. Her brain can't keep up and she gets tired. Yeah. Yep. My nurse Cal, just watch all the calls, the travel after she left. Yep. Hoss long to dying cold, says Nurse Cal. And What the Duck is encouraging my swearing. I love Spicy Mel. Thanks for the 10. All right, they're coming back. Wonder if Brennan's using AI for his arguments. That's a good random thought.
Defense has to make a decision as to what you intend to provide me so that I can make this ruling. So, all right, next is the Commonwealth's motion in limine to exclude the expert testimony of Garrett Wing. I know nothing about this person other than your motion just says that all you have is...
I know nothing about this person other than I saw him interviewed on Melanie Little's YouTube channel, and I do not like her at all. Yeah, right. You don't know anything about him. Come on. Does anybody believe that? Listen, I don't know anything about him. Oh, come on. Come on. You guys get all your information from YouTube and Twitter.
To exclude the expert testimony of Garrett Wing. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
If you're
I'm
letting
going to
him,
address that, Your Honor.
Crosby.
How would you, I want to make sure I'm within your time constraints, so you want me to stand up?
Like 2 minutes. Just my first question is,
do you intend
who
to
is
call
this
him?
person and why haven't you complied with your reciprocal discovery
Because we didn't think you were going to allow Crosby.
Your Honor, because this witness is pending Dr. Crosby. And he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question. But that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule.
It's the reconsideration for you to overrule yourself because your answer was wrong on the law. Hello, are you here? Have you paid attention? I've already ruled on Crosby, right? It's just the reconsideration motion for me to overrule myself because I was so wrong on the law, right? Well, if you are going to allow a non-physician, a non-doctor, a non-medical doctor to opine about the cause of injuries to John O'Keefe's right arm, Your Honor, then we can introduce an expert who is not a medical doctor, but is trained in dog bites and biting and canine training.
Rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving and we don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed, and the Commonwealth shouldn't be in a compromised position.
Discovery deadlines have passed. How about this? It took her so ducking long to decide that Crosby motion, and she's wrong on the law, and there's a motion to reconsider, and now he's going to get up like the little tattletale that he is and say, well, the discovery deadlines have passed, Your Honor, so, you know. She's also denied the motion to adjourn the trial to the end of May, so jury selection is happening on April 1st, but you know what? It's going to be so long until the defense gets to put on their case, Mr. Brennan, because you've already said you're going to take at least 20 trial days, at least 20, right? Did he say 20, 25? And you still haven't handed over the Sallyport video, and you're still handing over the Sallyport video that you've had for 3 years as of yesterday, but now you're going to get up like a little whiny tattletale baby emojis, and say, but the discovery deadline is passed, Your Honor. You remember Big Case Mike? When Big Case Mike came on and he was on Court TV and he's talking about Karen Reed and he's like, I hate that woman. I hate that woman. That's what I want to clip Big Case Mike and just have play him. I hate this man. I hate this man. Wild. Wild.
Well, discovery deadlines have passed, and the Commonwealth shouldn't be in a compromised position of receiving late discovery and trying to deal with it. So I'd like a time certain.
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all your reciprocal discovery that you need to give the Commonwealth on this witness?
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
Can you do it by Monday?
No.
Yes.
Okay.
Is that acceptable, Mr. Brennan?
Yes, thank you.
All right.
Thank you, Your Honor.
Thank you.
Really, Brennan? Really, you don't know? You haven't watched my show with Garrett Wing 10 times already? Brennan? You haven't? You haven't watched all of his videos on his YouTube channel? He's got 2.2 million subscribers. Really, Brennan? You don't know what he's going to say? I interviewed him. I thought it was a pretty good interview. The long version of that interview was like an hour and a half, maybe 2 hours. I cut it down to a shorter version for people to digest. That was like 30 minutes before I discovered the blackout shades and the sun is in my face the whole time. But you mean to tell me that he did not watch that interview? You know he does. He knows exactly who Garrett Wing is. Prick.
So 607, Jim, is the defendant will provide reciprocal discovery by Monday, the 24th. All right. The motion, Commonwealth's motion eliminate to exclude defense expert Michael Easter's opinion of the investigation. So I'll hear you on that, Mr. Brennan. I figure this is probably lengthier than the others.
I'm sorry, Your Honor?
I figured this might be more than 2 minutes, might be lengthier than the others we've heard.
The defense would like to call Mr. Easter to essentially testify about his personal opinions of.
This is the retired special agent from the FBI that the defense wants to bring in to talk about police procedure and how badly they screwed up the investigation, which goes directly to their Bowdoin defense, right? He doesn't like it.
The investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the role of the defense attorney to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses, and then the witness would have the opportunity to respond or explain or admit any type failures. This is an attempt to bolster a potential Bowdoin defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be.
No, it's not his personal opinions, it's his professional opinions as an expert witness in the subject. So, yeah, and Farmer, it's not exactly Farmer. It's not opinion if it's policy or procedure. Yeah. See how that works, Hank?
That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime. I've done quite a bit of research. This
No,
is not
actually,
a
he's going to come
summary
in and talk
witness.
about how shitty the investigation was. There's a difference.
This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different rules and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible.
Because, Your Honor, in Massachusetts, we believe that it's perfectly acceptable to collect blood evidence in solo cups. We believe that it is perfectly acceptable here to put those uncovered solo cups into a Stop and Shop bag that was used and then leave them next to the alleged murder weapon, Your Honor. So this FBI guy, he doesn't know the way we do it in Massachusetts. We also think that it's completely okay to leave a crime scene unsecured in a blizzard for 12 hours while another foot and a half of snow falls. So this guy who wants to come as an expert, he doesn't know how we do it in Massachusetts, Your Honor. Okay, you picking up what he's laying down? With leaf blowers. Yes, thank you. I forgot about the leaf blower. Not even a company issued leaf blower. In fact, Gallagher sent Sergeant Good home. Said, hey, dude, you got a leaf blower in your garage? How about you shoot home, shoot back, nobody gets hurt. Get your leaf blower. This whole thing is absurd. You can't even make this up. If you were in a Hollywood writer, it is a bizarre acid trip. Yes, it is. Yes, it is. It's my Grateful Dead posters in the back. You know, you know. We're all tripping together. We're on the same trip. The walls are starting to melt, and this man is still talking. And yet, is that Sue O'Connell with her head in her hands, who, by the way, I thought was very pro Karen Reed on the documentary. The things that she said were pro Karen Reed, which I found to be odd because she's not pro Karen Reed, I don't think, in IRL. It is a long, strange trip. The student, right? If somebody came, if in a Hollywood writers' room, if they were writing this, they'd try to pitch it, and they'd be like, "Yeah, nobody's going to pick up that pilot. It's completely BS. It's completely BS. Nobody's going to believe it. It strains credulity. You're not going to be able to sell that. No way."
And whether they can confront the witness And a witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest, like information in data records or phone records, rather a summary witness of a witness who wants to come in and give their personal opinions about this case. I don't see any grounds for admissibility for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different, and inevitably whether he thinks somebody is a suspect that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing for the defendant? So I need you to start by telling me what you expect him to testify to.
You don't like when Alessi tells you what he's going to talk about, so why are you letting you now? But you want him to tell you what he wants to talk about. Dun 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 dun. All right, that's the theme to Rocky, I think. But now she's going to tell him where she wants him to start because he shouldn't be able to make his own argument the way he wants to.
Testify to.
I can certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should look like.
How is he an expert on that? How is that a field, and how is he an expert on it?
I'll go
Is
through
it
that.
something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues specific to proper investigations and investigative techniques.
So put that in your pipe and smoke it, and then tell us what exactly James Crosby is an expert in and what he's going to testify as an expert in, because we still don't know. We still don't know. Nobody's told us. But you don't like the FBI because you know what? Maybe they're investigating you. Oh, now it makes sense. Okay, I get it. Okay.
Do you have a report and CV and all that material
Yes.
that you can share with me?
Sure.
All
I've
right.
already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, et cetera.
So is the basis of his testimony just crime scene, like collection of evidence, or is it
Witness
when
interviews.
somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too, both. Because if someone tells you as an investigator, someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like
even in the snow,
cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence, and things of that nature. There is certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side by side. They're nearly word for word. And the advisory committee notes for Federal Rules of Evidence 702 is very, very instructive on this particular issue, as specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the Rules of Evidence 702, the Federal Rules of Evidence 702, clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education, beyond that of an average layperson, in particular, in a field without, or in a particular field without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formerly coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all.
So I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either what I was reciting is either in the CV or in his report.
Okay, so that's what I need. That would be much more helpful to me.
Then I don't know what more the court would like for me
So
to
I wanted to know specifically what you intend to have him testify on, but if it's in his report.
It's in his, it broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him, we've already asked him to review. He's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training, best case practices for an investigative.
So I guess
technique.
that's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it, or is
So-
it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
All right, can you get me that report before you leave? Do you have it extra?
I think,
All right.
I think we probably have an extra copy of it, yes.
Mr. Brennan, did you want to respond?
I do.
Put that in your pipe and smoke it, Spanky.
Mr. Easter was a
Special
agent
agent.
who did
Easter.
CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel.
Monday morning quarterbacking by pointing out how shitty the investigation was. You don't need to be a Monday morning quarterback. You could be a water boy like Lally and figure out how shitty the investigation was. And the point is, they should not have to hire an expert to tell everybody that. But apparently, that's the way you do things in Norfolk County. Okay. Yeah. Edward says she wants you to tell her your trial strategy so Brennan can get a head start on his cross, right? It's true. Yes. It's not his personal opinion, it's a professional opinion. And we know how much Hank hates the FBI from when he represented Whitey Bulger. The playlist is in the show notes below this video.
So that they can use some type of opinion to lean on when they're arguing to the jury. They should have doubt because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that we'll never be able to have an opportunity to explain. Are we going to call in the Canton Police Department again and call in the state police for a second round so they can explain why they chose certain actions that Mr. Easter is criticizing? I don't.
No, perhaps you can have them explain that in your case in chief about why their investigation was so shoddy. Maybe you could have them explain why solo cups were a good idea from the across the street Deputy Chief of Police, Tom Kelleher, who, despite the fact that his guys were first on scene, Canton PD never came out of his damn house except to hand them the solo cups. Maybe you could get into all of that ridiculousness in your case in chief. Bev's Bishlap says, I just want to say, love you, Mel. In case I stroke out, I love you more.
I don't think this is an appropriate ground for an expert witness. I don't see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowdoin defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowdoin type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What
It's
if
so funny. Pot me kettle, your whole James Crosby. We don't know what he's an expert in at all. At least we know this guy's a retired special agent from the FBI. And yeah, you've never seen it before because there's never been such a shoddy investigation in the history of the mankind. In the history of the whole United States of America, there's never been a more wrongful persecution and a crappy investigation than this one. And you guys are the ones who decided to charge her with murder. So, there's that.
Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances. What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom.
No.
We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony. This is argument by counsel.
Oh, AJ, get up. He's like, he can't even get out of his chair fast enough.
I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder.
Yes.
He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. Yeah. That's what you're supposed to do. And then he says, well,
You wouldn't
hang
be
on.
objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Oh, no. Mr. Brennan said,
His
what if
own
I
witnesses.
called a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it. Do it. I'd love that. I'd love a shot
Okay,
at that.
so I said, let's take personal.
That's
out
not
of
an
this.
invective. That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we are entitled to present a defense. And part of that defense, the Bowden defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within.
I don't know. So if you can give me a case site for that, all right, that
I'm sorry, what?
expert testimony regarding a Bowden defense. I've never seen it. I've never seen it in research or anything. So I'd like a case site.
There are certainly cases outside the jurisdiction.
Yeah, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case.
There's never
where
been
this
such a
has been
shitty
done.
We have searched
investigation.
and searched for a specific case in Massachusetts. There, to my finding, to our finding, there isn't one directly on point, but there are plenty. There is a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Right.
That is an expert field, one that's utilized throughout the
So
country
I
all
need
the
some
time.
authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right. So I think that's it for the motions in limine.
That's the case.
Did I miss anything?
Do it. Do it.
All right.
We have a smooth as butter emoji for Alan Jackson for a reason.
Well, I need that. Oh,
Your Honor, earlier you alluded to, what defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first.
They can't agree on anything. They can't agree on anything.
Is that your understanding, Mr. Brennan?
Yes, and we have not.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
I regret we don't. We have not spoken.
Your Honor, if I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back.
Stop the presses. Laura McLaughlin is getting up to speak for maybe the second time ever as co-counsel of the prosecution. And now Hank is looking at her, throwing daggers at her like, how dare you? How dare you take away my spotlight? How dare you? Mark the date and time because this never happens. She's never allowed to speak. The judge wants a one-page jury questionnaire. And I said, what? Can we do it in 4-point type? Let's see what she's got to say about it.
One point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional one-page juror questionnaire that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate
Right.
questions. If in additional to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think.
Right. Have you ever watched Attorney Melanie Little YouTube channel? Have you ever watched Lawyer You Know? Have you ever watched Emily D. Baker? Have you ever watched Runkle? Have you ever watched Andrea Burkhart? Have you ever watched Defense Diaries? Have you ever watched Uncivil Law? Have you ever Is that what they're going to ask in their questionnaire? Wow. Ever watched The Galera? Young Jerks? You ever watch any of the Canton board meetings on YouTube?
I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of publicity, even far more than the last trial and so close to jury impanelment, it makes sense to me.
Because we all know how bad this case sucks. Yeah, I couldn't name everyone. Sorry. Yep. Recovery addict, Brandy Churchwell, Turtle Boy.
No, there's no objection.
They definitely
All right.
should ask about Turtle Boy, but I didn't want to, I didn't want to add him to the mix right now because, they're already trying to get his phones and all. Because the whole thing is a sham, yes.
Joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties.
Chisholm.
All right. File your questionnaire, file your proposed questions that you would like me to ask the venire and that you would like to ask at sidebar. I need that by tomorrow. So tomorrow by the close of business, I need that. So,
I can't with this. I can't.
If I need to see you again next week, we'll let you know on Monday. All right?
Yes, Your Honor.
Okay.
Well, obviously, it'd be a day after Monday then, Judge, right?
Yes, Ms. Giannetti, it would be after Monday.
We did file 2 motions today that at some point we'll
What?
meet hearing on.
2 motions today?
Okay.
The defense just received notice this morning, so they're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
How much you want to bet that Alessi could read your crappy papers and stand up there and argue them on a cold read? On a cold read. How much you want to bet? Look, they're handing him the papers right now. My freeze game's on point. He filed 2 motions this morning. But, he wants to get up there and whine to mommy about they missed all the discovery deadlines. The discovery deadline's over. So, there's that. He filed 2 motions today. I think the motions in limine deadline was like a week ago, Monday, right? I don't know. Could be wrong on the date, but really? Unless he'll be like, I'll argue it right now, Judge. Let's go. Yes, they did put her lawyers on the witness list. I have it here. We're going to look at it in a second. Thank you, Spanky Alfalfa and Darla's Playground. The little rascals. That's what we call those 3 at the front table. Spanky Alfalfa and Darla. And it is their playground because, they're the ones who get to just do whatever the duck they want, spin around on that little, what's that thing called where you like sit on it and then one person spins it and then the whole thing spins around and the kids are sitting on it. What are we just turning the cameras away? Are they done here? Hang on a second. I got to mute this family chat. These kids need to get on YouTube and know that I'm live and mute the family chat. Okay. Although my kids are freaking hilarious. So I'm sure whatever it is that they're chattering about is really, really, really funny. Tilt-a-whirl, sit and spin. Oh, the sit and spin? No. Yeah, I know. It's like a big metal thing and you sit on it and then somebody would spin it around. But a lot of kids could sit on it. So yeah, I know the sit and spin was like only for one kid, not a merry-go-round. Nope. I don't even know if that thing has a name. So wait, did we get any information on when we're coming back? Oh, maybe now? Wait, hold on.
Okay, thank you very much.
Thank you.
It's like a big metal thing. A bunch of kids could sit on it and then somebody would spin it around. It would just spin around, not a merry-go-round, because it was like you had to physically spin it. I don't know. Maybe it doesn't have a name. I don't think it has a name. The puke machine. You spin me right round, baby, right round. Wow, what a day. What a day. Hold on. Let's zoom in while Karen talks to her. Do they even say when we're coming back? Have you ever watched Turtle Boy? That'll definitely be on the questionnaire. Yeah. Wow. Just wow. This reminded me of when I at lunch when I had to get up and stretch because I'm not feeling that great. And I was like, I got to get up and stretch. Who was the person on Saturday Night Live that we should be like, my name is Sally O'Malley. I'm 50 years old. I like to kick and jump and stretch. I forget who played her on Saturday Night Live, but it's hilarious. And that's all I could think of was, my name is Sally O'Malley. I'm 50 years old and I need to jump and kick and stretch, although I'm much older than 50 years old. But I digress. Let us take a look now at the, oh yeah, we're going to recap. But first, what I want to do hang on, is look at the witness list that was actually filed this morning by the Commonwealth. They said they also filed 2 more motions. We're not going anywhere just yet. I'm getting a little bit of a second wind here. Not much, but just a little bit. So let's just, pull it up. Where did I put it? I put it somewhere over here. Okay, well, that's one motion. Rule 17 motion. We don't need that. We don't need that. That was an Aidan Kearney motion from this morning. Boy, we've been through a lot. We've done a lot of things today. No, where's the Commonwealth's witness list? So it's not 603. It's got a new docket number. Hang on one sec. Let me find it. I thought I downloaded it. Talk amongst yourselves for a second. Talk amongst yourselves for a second. Here it is. 614, 614. So they've already filed a witness list. The first witness list was docketed as 603, and that one had a total of 86 witnesses on it. This new one is docket number 614. And let's pull that up. Give me a sec. So this is the new witness list or witless list that they put up this morning. What did I say? The first one had how many? So this is 614. I'll take this down so you can see it. And they've added Karen's lawyers and maybe some other surprise guests or witnesses. This is dated yesterday. It's got all the footnotes. I think Natalie. So now it's got 91. The last one, what did I say? Had 86. So there's 5 extra witnesses. 3 of them are Alan Jackson, Elizabeth Little, and David Inetti. And then they have a little footnote here that says the Commonwealth notices it may be necessary to call defense counsel to authenticate the defendant's numerous public statements. Yeah, good luck with that. We do. Remember one day we had a yoga instructor come on and like do heavy breathing with us. She did breathing with us before a Karen Reed hearing. She did like some relaxation techniques with us, right? We had her one day, and then there were people who were tuning in, and they're like, it was so lit. The chat was hilarious out there. They're like, what the hell have I just walked into? She was amazing. And Kelly Reed says, you're going to need to have her back before every hearing now because we just can't. Okay, so here's the new witness list from this morning. And it says here, footnote 1, prospective witnesses, which, in their Commonwealth's prospective witnesses witness list, footnote 1 says amended March 19th of 2025. But, as you can see from the stamp, it wasn't docketed until this morning at like 8:45 because, somebody was in the clerk's office early. No, I think they actually open at 8:30. So my bad. And then it says, again, civilian witnesses. We've got all the Alberts, Brian, Bry Jr., Beej, Caitlin, Chris, Colin, Julie, and Nicole. And then Stephen Bernstein, keeper of record. And then footnote 2 up here, witnesses who may be called to testify in this case says, the Commonwealth moves to be partially exempt from Massachusetts Criminal Rule 14, B1C, effective March 1st of 2025. So all these Rule 14 was revamped. And guess who was in charge of that committee? Oh, Judge Kearney. She was the head of that committee. Molly Shannon. Thank you. If anybody's put it, my name is Sally O'Malley. I like to jump and kick and stretch. Yeah, Molly Shannon. Love her. Rule 14 has been since revised. It just took effect March 1st. Judge Kearney was the head of that committee. And it wasn't Sue. I know. I looked back and I'm like, oh, that wasn't Sue O'Connell. It was a different guy. Yeah, sorry. And that's Rule 14 is the automatic disclosure rules, automatic reciprocal discovery rules. And I think that the reason that she revamped them or wanted them revamped is exactly because of this case and all of the things that the prosecutor didn't do in the first trial. So as he said this morning, they want to be exempt from the new rules that require the Commonwealth to produce the names, addresses, dates of birth, and known contact information of the Commonwealth's prospective witnesses other than law enforcement witnesses. The Commonwealth asserts that given the ongoing harassment of witnesses, threats to witnesses' personal safety, and the highly publicized nature of this case, there's a special circumstance warranting non-disclosure of the witness's address, contact information, and dates of birth. What about all the people that went and did like bad Google reviews on ARCA, and didn't somebody have to take their website down because of like the harassment they've gotten from the people who think that Karen Reed hit John O'Keefe with her car and should burn in town square like a witch? I digress. They want to be exempt from that. What exactly did the judge say? I could go back to my notes, but they're messy and I can't read them. And I don't remember if she took that under advisement. Is it called the Galaxy Wheel, that thing? The red eye. LAX to Boston's red eye. That was the playground thing? Maybe. Yes, Lisa, we're going over that exactly right now. All right, here we go. That's page 1. Then page 2. Let's see who else we can I spy in here that's new. We got to find 2 more. We saw the 3 attorneys on the back page. Aidan Kearney's on the list. We talked about that the other day. Caitlin Boudreau. I can't remember. I think these are all the same. Margaret O'Keefe is Peggy O'Keefe. I guess they called her Peggy and she didn't like that. Natalie, the German, is on the list. Number 39. Natalie Wywicki Berschneider. She's the one that they went to California to interview. Like Yuri. Was it Yuri and Fanning or Yuri and Tully? Went to interview Natalie, the German, in California because of this investigation of Aidan Kearney. And they were trying to show that Aidan and Karen colluded. And then who else? There's got to be one more we didn't notice before. So let's look at these. They all look the same. If anybody can point it out to me so I don't have to go crazy trying to find it, that'd be great. That'd be great. He said he wasn't calling them, but he still left them on the list, eh? The roundabout. Is that what it's called? The roundabout next to the monkey bars? Yes. Yes. It was a roundabout. Lisa Proctor on here. Terry Kuhn. Did they try and sneak in another expert? Let's see. Oh, you think it was Peggy? She wasn't on the first list? Oh, good. That would help me. That would really help me greatly. Let me go back to the first list and just see, because I have that on open on another screen. Hang on. Yes. Thank you. Thank you. Thank you. They only had Paul and Aaron on the first list, and now they have Margaret or Peggy O'Keefe on the first list. Thank you, Cheryl Rose, for saving me time. And then again, they've got her attorneys on the list because, they need to come in and authenticate her statements that were made to a reporter. And the proper way to do that would be to bring in the reporter. I'm scrolling, but it's not the one that I have on the screen. Thank you, Cheryl. Thank you so much. Peggy, Natalie, and the 3 attorneys. You guys are awesome. You're awesome. Let's go back to the chat for a minute. Thank you, Southern Mom. I put this up before, but I just want to say thank you. A New Hampshire woman, I put these up before. And Al Dente put that up. Nina says he doesn't like the feds. He wasn't invited. Good Norfolk says all new court officers. Am I seeing this correctly? I don't know. Were they new? I didn't notice. Springer Love says, why is she forcing the defense to name third-party culprits so Marcy can groom Albert and Higgins? Maybe. But he did name them. He said Brian Higgins, Brian Albert, and Colin Albert. So many things were just taken under advisement today. We really didn't get resolution to much of anything. Random thoughts. Haas to do an investigation with red solo cups, butcher paper, and a 1 Q-tip. Well done. Siobhan, don't you just love Alan Jackson? We do. We do love Alan Jackson. We have a smooth as butter emoji for him here. U.S. Marine Corps cowgirl, Semper Fi. Spanky's theme song, Godsmack, crying like a bish. Thank you. Canoni's disproportionate disdain. Definitely, defendant has entered the F around and F out. F around and find out, school of thought. Yeah, they're mad. Sandy B says you will never get anyone to testify. They did an outstanding investigation, right? Good luck trying to find that expert. Tommy H. So their argument is she was so calculated she could act like she still liked him long enough to run him over in front of a house full of cops and law enforcement supporters. Yeah. Pretty much, yeah. That's pretty much it. Yeah, that's it. That actually absolutely is it. My nurse Cal, every objection without reason, they should stop the trial and go ask the judge what the objection is for. Call it the clarification. Yeah, that's the way it's done mostly everywhere else. My nurse Cal seems to be a Massachusetts special rule. This case just gets crazier, says Dawn. She's been here for 5 months. Thank you, Kelly. Kelly Reed says, do it. We need the yoga breathing exercise guru to come in. Jen Altman says, I drove 300 miles today seeing patients. I listened to you the entire time. Thanks, Mel. Thank you, Jen Altman, for allowing me to keep you company in your car and for treating the patients. Oh my God, I don't know what the hell's going on here. This is a mess. It's a Michigas. What a fakakta. Britta Mad Hatter says, I could not be a lawyer. Bev made me flip off my TV. Yeah. This was wildly insane. Starting off the hearing in front of a different judge that you guys told me his name, because Hank Brennan now is intervening in the Aidan Kearney case to get Aidan Kearney's communications between Aidan and Natalie the German, who you just saw is on the witness list now, so that he can show allegedly consciousness of guilt on the part of Karen Reed by using Aidan Kearney's phones. And Tim Bradle did a bang up job and a great argument. And I think, you know what I think we need to do? I think we got to play that again. Because if you didn't see that, I want to play for you just the walk in when the defense team walked into the courtroom and they were like, what the hell is going on here? Why weren't we invited? This is outrageous. And what they went to sit down and they were like, the judge was like, what are you doing here? You can't sit there. And then he reversed himself. Mama, she says, I'm so glad to hear you. You're here walking through the trenches. Thank you so very much. I appreciate you just as much, if not more than you appreciate me. Let's go and see if Court TV had that on their feed today, because that was like the Rocky theme should have been playing for that. And it was insanity. Let me just see if they have it even on Court TV. Because a lot of people didn't get their feet up in time for that hearing. No, Court TV starts with Brennan. So let me go back to my own history and see who we watched at the time. I think it was Boston 10. Hold, please. Talk amongst yourselves. Must have been Boston 10. They had the cameras up. Let me just find the part. Talk amongst yourselves for a second. Oh yeah, this was fantastic. Oh, it's so good. This is so good. All right, it deserves to be. All right, let me pull it for you. Thank you, Mama Shea, for your 20. Appreciate you so much. All right, if you didn't see this, just get ready because this is fire. Absolute fire. So Brennan is arguing why he should be able to get all the records from Cosgrove, who's the special district attorney assigned to persecute Aidan Kearney. And they have this hearing that nobody knew about. It wasn't on the court calendar. It's in front of a different judge. I'm going to find his name for you. I have it in my notes. And nobody knew what was going on. We couldn't get a Zoom feed. And then the cameras went on. But we saw them walk in. Why do we see him now already sitting there? We saw the walk in, didn't we? Oh, hold on. That was the best part, was the walk in. Hold on. Were we watching Boston 25 at the time? Um, I don't know. Do you guys remember? I thought it was Boston 10. Tom CPU, maybe he had it. Yeah, maybe that's where it was. Everyone give Tom and Boston Michael a love. Give them some love. It was in the morning. Hang on. It's worth it, I promise. Okay, so there was Aidan sitting in the courtroom.
minutes was passed purposefully from Karen Reed to Mr. Kearney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
That's the intermediary, Natalie the German. All right, let's see when they're walking. Hold on.
The substantially itself, or in the critical issue here with regard to the purported relevance of the data sought? Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
Everything was bad about this.
I understand they are available to Special Prosecutor Cosgrove, and I confirm because I have not, because I purposely not
elaborate
the intimidation. Kearney.
Oh wait, so
Many
maybe
page
long crime.
affidavit that we have.
So, how from the affidavit, data include material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
Well, we're a little confused, and I don't mean to interrupt the proceeding, but as we'll.
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of. We didn't see which case number was called, Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Kearney, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights and the.
Wait, I'm flipping over to here so we can watch it. I don't know if it was Tom and Boston Mike's stream or if it was the long crime stream. That was a little bit wonky. So let's just see this again because watch the court officer at the door. Brennan has no idea they're showing up. He thinks he's doing this totally on the sly. It's not even on the court docket today. And here comes Alessi. He's the first one in. Ready? So Hank Brennan is talking. And here they come. Cue the Rocky music. Watch their faces. This is fantastic. You're going to love it.
Everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
Well, we're a little confused, and I don't mean to interrupt the proceeding, but as we'll.
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of. We didn't see which case number was called, Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Kearney, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights and the issue.
This meeting is being recorded. Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here and she has a right to counsel, and we have a right, we believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to prosecutor asking for information in her case to move forward, her consciousness of guilt, et cetera.
Those are evidentiary issues, counsel,
Correct, but we.
which can be dealt with at a later time. Those are, what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time. This is.
But if the motion was filed in front of Judge Kearney under Karen's case number, why is a different judge hearing it and having Aidan Kearney present? Why wasn't this done in Judge Kearney's courtroom? And Aidan could have had his lawyer present, similarly to the way that we saw in the first trial when they wanted Brian Albert's records and Jennifer McCabe's phone records. It was in front of Judge Kearney. They all brought their lawyers in, and they got to argue on behalf of their clients. Jennifer McCabe was represented by Kevin Reddington, who thinks that I'm a very credible source on the YouTube, by the way. Why is this not in front of Judge Kearney? What if it was filed under the case number for Karen Reed? Why is a different judge hearing it? Why is it being done in secret? Why is Brennan not putting the other side on notice? There's so many things wrong with this. And it made no sense to me at all. This is what you call trial by ambush. Yeah, he loves to throw that around, trial by ambush. And he thought he was being slick, and it wasn't on the court docket, because you can go right to the website for Norfolk Superior Court, and you can pull up the daily calendar. It's not on there. So weird. And Aidan didn't know about it until like almost 10 p.m. last night, because one of you guys sent me his tweet, because I don't play on the cesspool of Twitter. But this judge then does say, okay, you can sit there. So listen.
Respectfully, I don't necessarily disagree that from an evidentiary standpoint or the disability standpoint, that can be dealt with at a later time. But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument
because
as it intends to, and we're prepared.
Did you give the court notice?
Because it's in front of Judge Kearney. This is not in front of you, Your Honor. Why are you hearing this in secret? I'm gonna show you today's daily court docket. This is today's daily list for Norfolk Superior. Okay, this came out this morning. You can get this every single day. Here's Thursday, March 20th is the day, right? You've got a hearing for a change of plea, and here's the defendant's name. This guy has two things on in front of Judge Kearney at 9 a.m. And then there's a pretrial conference for Karen Reed in front of Kearney. Here, Reed, Karen. And then page 2 of today's daily calendar has a whole bunch of civil cases on it. As you can see, 1, 2, 3, 4, 5, 6 civil cases. And then some other cases at 2 p.m., none of which are this case. So how did they get it in front of a different judge? Why was this being done in secret? Somebody said it's on the docket now, but not on the early morning calendar. Maybe it's in the court docket as having happened, but it's wild. Totally sus.
We did to Justice Kearney.
Okay.
Day before yesterday.
Whirly gig. Is that it? The whirly gig?
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr.
But yes, I do. Yes, I
Ms.
do.
Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, of the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Gradle is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally. The council wants to join in my filing. That's an issue in terms of the filing. So just put it
That's right. So instead of putting something in writing, you can just say, and you can put it in writing, and you can just say, for purposes of judicial economy and brevity, we adopt all of the arguments as set forth in Timothy Bradel Esquire's opposition papers. We join in his papers. We make all the same arguments. And he can just do that verbally too and say, you know what, we don't need to put in opposition to this. We agree with everything Mr. Bradel said. And so let's go. It was unlisted. Motion for a do it emoji granted. I mean, wow. Thank you, Maura, for the Venmo. She says it's called a whirly bird, right? I don't know. Whirly bird, whirly gig. I don't know, but you guys are sending me emails about it, so I'm sure we'll figure it out. Thank you, Donna, for the 3 matcha lattes. She says, today has been so mentally exhausting. Thank you for taking us through it. I confess I ran on the break to buy wine. It is okay, Donna. I will allow it. On a school night, no worries, no judgment. This is a judgment-free, troll-free zone, you know? So there's that. Thank you all for the many, many emails that you've sent me today. I always read them. I do not always get a chance to respond to them. Thank you, Lori, for thanking me on Venmo for my commentary. I appreciate you all so very, 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 very much. And Patricia for buying me a matcha latte. You guys are the greatest. Let's see. Anything else here that we need to address? Dennis, thank you for the Venmo. Says, I really thought you were going to quote Jackie Chili, lewd, lascivious, salacious, outrageous. No, but I don't get that reference, but I'll look it up. Colleen said, Free Can Read, I love watching your facial expressions and hands while listening to Brennan because I'm doing the same thing. I think this is a fine example of who I would never hire to defend me. I don't live in Massachusetts. Thank God, Colleen. Thank God. And not that, look, I'm not dissing any of you guys who live in Massachusetts. You know, my Boston accent is done with love. I love the Boston accent. You know that I'm not yelling at you. I'm yelling with you. And it seems to me that one of my moderators has pointed out that it is something that trolls like to do. Trolls like to come in and troll the chat about the volume just so that I'll get pissed off about it. And she or he is probably right. Amber Dawn Them Johnson says, not sure if any rap songs made it to the playlist, but I think DMX's RIP song Party Up absolutely deserves consideration. I will allow it. I'll put it on there. I have a list somewhere. Y'all gonna make me lose my mind up in here. Yeah, that's a good one. What's it called? Party Up. All right. And we already have also, she's already made up her mind, is already on the list. All right. So what's it called? Party Up. Party Up. Let's take a look at who this judge is because we were all wondering. And if you didn't watch this hearing from this morning, it's fire. Go back and watch it. Kelly, Hank Brennan's the pro sector's law spell check says, I'm behind, but I'm sure Bev said that surely they weren't going to call all 3 ARCA witnesses. And the defense said no, 2 will, and Bev agreed. Somebody pointed out to me that she did not allow one of them to testify because he didn't have a PhD. So I'm going to have to go back and when I have time and do some homework on that. Here's the judge. His name is Adam Sisitsky. And that's his LinkedIn picture. And so far, I don't know. I'll allow it. We like him. Do we like him? How do we feel about this judge? I thought he took it under advisement. So we don't know. We don't know if they're going to allow it. So there's that. Megan said, watching Bradel argue in court in person on Tuesday was out of this world. Oh, did you go to court on Tuesday, Megan? That's awesome. You were in Aidan's hearing on Tuesday. That's fantastic. Good on his feet and not afraid to hold back. Great energy. I know. I could just tell. Have I met him? No, I've never met him, but I would like to. I get that vibe too, that he's got great energy. Thanks for validating my feelings. Mrs. Bouquet, thank you for several super stickers today, which I put up on the screen. CPU Mod 1, who is also known as Tom CPU Sister. Thank you. Says you make this so much easier to watch. You have me laughing out loud. True love for humility. Oh my God. People think it's easy to do this, like we're a bunch of hacks up here. We're a bunch of grifters doing this. I'm just going to say that, first of all, there's a lot of preparation involved. Second of all, to keep 10,000 people engaged for close to 7 hours straight is not an easy feat. If it was easy, everybody would do it. And I suggest that if you want to go on Twitter and talk about how much you hate me, just try and do what I do for one day. But thank you. And everyone, please give Tom CPU and Boston Mike a big like because we did swipe their stream for a little bit this morning. And it was thank them for doing that because they had the camera up when nobody else did. And we couldn't even get the Zoom feed to work. So go over and give Tom CPU and Boston Mike a like and a sub, because they do all the dirty work and they're there in the morning. They're outside the courthouse. Thank you, CPU Mod 1. Edward says, Unity's face as he walks in, laser beams at Hank. Yeah, if looks could kill, they probably will. And I think that is on the playlist, right? Games Without Frontiers. I think we have that on there. Love me some Peter Gabriel. Thanks, Edward. Al dente, fart left over from Brennan. Yeah, perhaps a shart. Mudrocker, they only added it to Karen's docket after the hearing started and noted defendant not present. No notice appeared ahead of time. Nothing on the calendar. It was 100% dirty pool. Wow, Mudrucker. Wow. We also found out that Brennan has filed 2 motions this morning. Don't know what they are, but guess that'll be something for us to look at tomorrow, because are they coming back tomorrow? Are they coming back tomorrow? Oh, they love me too. I love them. I love everyone who's like nice and normal and, fighting for justice out there. Did she even say when they're coming back? Susan's here. Everyone in Southern New Hampshire loves you. AJ and Alessi Spanky witness that they called him a douche canoe. Thank you. Susan figured it out. Thanks for not spelling it out. YouTube has an AI program that goes through the chat, and if there's a lot of curse words in there, they kind of sometimes strike you. Ms. Bouquet says it is bath, book, and bedtime for the little ones. Thanks for the stream. Love your channel, Mel. Good night, all. Love you more. Love you more, Mrs. Bouquet. Love you more. Peace. Amber Dawn. Yes, we addressed that one, right? Up in here. Should Bev be annoyed regarding the earlier court stunt? She should be. She should have grave concerns about what went on this morning, but will she? Yes, Donna bought a matcha latte and says, I came in like a wrecking ball. I put that on the list. It's on the list. Should Bev be annoyed? Yeah, she should. All planned while Judge Doolin is on holiday, in my opinion, says Jadzia. I think you're right. Attorney O'Leary is here and says Aidan's face is priceless. And 13 Flag says, so would this be the most appealable case ever? If there is a conviction, which I highly doubt, yes, there are so many grounds for appeal on this, and I would defer to Andrea Burkhardt on this. She's an appellate lawyer, as is Kurt from Uncivil Law, and they've done some great streams on the appellate issues on this, and they're far more qualified to opine about that than I am. I'm a trial lawyer, and so I would defer to them on that. But yeah, there's so many appellate issues here that it's not even funny. All right, I'm losing my voice. I'm losing my mind. I'm losing just about everything today. And I thank you so much for spending your day with me. And I thank you to the moderators for keeping it classy and for being amazing. And the super chats keep coming in. I told you guys, I pinned the defense fund in the chat. You should be donating there. Just cannelloni. I'm so completely lost. I've been watching everything over and over, and everything makes less sense the more I watch. Thank you. And KT, the judge looks like Ben Stiller a little bit. He does kind of, right? Yeah, I'll allow it. Judge Sisitsky. They are defending the Alberts. It is so obvious. All of it. Thank you, moderators, for keeping it classy. This is impossible to do without you. I will send you all pizzas tonight. If you would like a pizza, text me and tell me where to send it. I will DoorDash you pizza from the chat. Tuesday at 11, we're going back, Cal? Tuesday at 11. Thanks, Kelly Reed is here. Tuesday at 11. Okay, I'm traveling end of next week, but you know how I am. I always have my equipment with me. But I'll be around on Tuesday, so that's good. I love you with all of my heart. If I don't see you all soon, I'm gonna die. Just Google Clemenza's Meatballs on YouTube, and you'll know exactly what I'm talking about. And just stay cool, stay kind, stay classy. Get your I went to Cancun with attorney Melanie Little merch. Some of it has free Karen Read on the front, and it's on the back. And this is the orange color. It looks a lot more orange on the website. It is actually this color, just so you know. Please do all the things that YouTube likes, like hit the like, comment respectfully, and do subscribe, because I really, 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 really want that silver 100,000 subscriber button that I could put behind me somewhere, because Vinny has one, and now the competition, I lost. Jam Cracker, thanks for settling the bet between my hubby and I on when you drop your first F-bomb. Oh, did you win? Oh, I love you and your coverage. Oh, thank you. I've done it on other channels, not my own. Earmuffs may be required for some of the children. Sorry, but sometimes you gotta know that it is the perfect word. The F word is the perfect word. You can use it as a noun, an adjective, an adverb. All the words. It is multi-purpose. I try not to say it, but sometimes you just can't help yourself. Can't help yourself. Thanks, Feds. For becoming a member, a floor seat member. All of my membership levels are concert based because we have general admission. Then we have, I think, floor seats, and then we have VIP, and then we have backstage pass. That's because I'm a concert goer. Look out, Sphere. Here I come. All right, everyone. Stay cool, stay kind, stay classy. I love you with all of my heart. If I don't see you soon, I'm going to die. And stay safe, and also stay calm. Stay calm. Maybe we'll do the deep breathing next time. Peace out, my friends. Enjoy the rest of your evening.